The Committee on Criminal Jurisprudence will come to order, and the clerk will please call the roll.
Chair Smithy,
Here.
Vice Chair Wu, Representative Bowers, Representative Cook,
Here.
Representative Jones, Representative Little,
Here.
Representative Louderback, Representative Money, Representative Moody, Representative Rodriguez Ramos, Representative Verdell.
A quorum is present, so we'll go ahead and begin, members. First of all, we want to welcome everyone who's here today in support or opposition to any of these bills. We look forward to hearing from you. We welcome your testimony. It's very important to us to hear what comments you have on the bill. I would ask you this, if you intend to testify today, or if you intend just to register your support or opposition, be sure and fill out the witness affirmation form, which is electronically available on the kiosk outside. And because just to keep the record clear, I can't let anybody testify unless you filled out the affirmation. So if you will do that, and once again, you don't have to testify. You can register your support and opposition, which the committee will have access to your support or opposition just as by virtue of filling out the form and indicating you do not wish to testify. We are convening, of course, this morning at 10:30. We also have a session beginning at 2, so it will likely be necessary for us to stand in recess for while the members go to the floor. If that is the case, we will resume our committee hearing as quickly as possible after the floor, and the record will show Vice Chair Wu is present, and Representative Bowers is present. And so we will resume our hearing as soon as possible after we leave the floor, depending on the terms of the adjournment upstairs. And so we'll come on over here and resume this hearing. A couple of other things. Members, we've got a bill that, I'm sorry. Okay. What bill? Okay. We have House Bill 305 that the chair would intend to vote on at some point later in the meeting, probably if we're coming back after lunch, right after we come back. I want to make sure we've got all the members here, if possible, when we vote. And it's House Bill 305 by Representative Hayes, I believe. There is a committee substitute on that bill. I think you should have that by now. If there's any other bills y'all want to vote on, even if not this week, we can get those. If we can get a card showing we've got the votes on the committee, we'll try to bring those up when we can. So we'll vote at some point in the meeting today when we have everyone here. The other thing that I need to do at this time is to announce a subcommittee. The chair announces a subcommittee with Representative Louderback as chair, Representative Moody, Representative Money, Representative Bowers, and Representative Little. The subcommittee will consider bills related to new offenses and changes in penalty for existing offenses. I think this is a very important subcommittee because the main charge to this subcommittee is to make sure, first of all, we don't try to pass conflicting laws this session because we've got a lot of bills on those topics, and also to make sure that any penalties that we impose, ultimately that we vote on, are consistent and meet a pattern that is relative to the relative severity of the offense. The other thing is to make sure that we're not conflicting with existing laws that are already out there, and so that's going to be quite a job, quite a responsibility. And I would hope that next week in this committee, a full committee, we set a relatively light schedule of a few bills, and then the subcommittee could meet upon adjournment of the committee next Tuesday, if that's acceptable to everybody. Okay, so it is the subcommittee on new offenses and changed penalties. So at this time, the chair would refer the following bills that meet that subject matter description to the subcommittee. And once again, it's not a subcommittee just to bury these bills, but really to do some substantive work and make sure what we're passing out of here is a good work product. So House Bill 108 by Plessa, House Bill 285 by Ordaz, House Bill 288 by Bumgarner, House Bill 316 by Marianne Perez, House Bill 353 by Patterson, House Bill 379 by Guillen, House Bill 387 by Leo Wilson, House Bill 418 by Ann Johnson, House Bill 544 by Gervin Hawkins, House Bill 689 by Gervin Hawkins, House Bill 795 by Ann Johnson, House Bill 848 by Moody, House Bill 1092 by Shaheen, House Bill 1160 by Hull, House Bill 1255 by Toth, House Bill 1391 by Hopper, House Bill 1414 by Allen, House Bill 1422 by Hall, House Bill 1443 by Schatzline, House Bill 1490 by Swanson, House Bill 1509 by Hickland, House Bill 1572 by Campus, House Bill 1668 by Gertis, Cook, and Wilson, House Bill 1713 by Plessa, House Bill 1789 by Gertis, House Bill 1795 by Anchia, House Bill 1871 by Dyson, House Bill 1891 by Cook, House Bill 1902 by Cook et al., House Bill 2073 by Hull, House Bill 2407 by Capriglione, House Bill 2430 by Capriglione, House Bill 2444 by Hickland, House Bill 2593 by Metcalf, House Bill 2666 by Verdell, House Bill 2695 by Anchia, and House Bill 3061 by Oliverson. So those would be the bills that would be referred to the subcommittee to look at. So any objection to that, members? If not, we'll go ahead and do that. And then I believe we're ready to start hearing bills. Which bill did you have? Okay. Ms. Thompson, in pecking order, you would be the first, but I've got to get Mr. Ashby on because of one of his witnesses, if that's okay. So the chair would call up House Bill 2000, and recognize Chairman Ashby.
Chairman Smith, the distinguished members of the committee, thank you for the opportunity to lay out committee substitute for House Bill 2000 before you today. Mr. Chairman, did you recognize the committee substitute?
Okay, there is a committee substitute, so Mr. Cook will lay out the committee substitute.
Okay, thank you. And also I want to thank Ms. T for allowing me to go first this morning. Thank you, Ms. T. Members, it's with a heavy heart that I bring this bill before you today because this piece of legislation was filed in response to a tragedy that occurred in my district. In February of last year, an 11-year-old girl named Audrey Cunningham was kidnapped and murdered in Polk County. After her body was recovered from the Trinity River, the details that came to light as a result of the investigation were so gut-wrenching that it made national news, and it prompted an outcry from a really tight-knit community in Deep East Texas as well as across our state. The man who killed Audrey Cunningham, Don McDougal, was living with Audrey's grandparents who were helping McDougal get back up on his feet. Unbeknownst to them, McDougal had a criminal history that, had they known at the time, would have stopped them from ever letting this monster into their home. Before Audrey's death, McDougal had been accused of indecency with a child after attempting to molest a young girl in 2007. Because the prosecution had no evidence to prove that he committed this act of molestation, McDougal struck a plea deal and was charged with the lesser charge of enticing a child, which does not require the offender to register as a sex offender. I can't begin to imagine the pain and the outrage this family felt after learning about McDougal's troubled past. And this bill, House Bill 2000, Audrey's Law, seeks to prevent tragedies like this from happening in the future. This bill would simply add a requirement for individuals convicted of child grooming to register under the Texas Sex Offender Registry. During the 88th legislative session, as many of you will recall, we created the criminal offense of child grooming in the penal code. To paraphrase the statute, a person commits an offense if they knowingly attempt in sexual activity with a minor. While this new offense is certainly necessary and carries with it a felony charge, the offense does not require the offender to register as a sex offender. Adding this offense to the list of crimes that require registration under the sex offender registry will strengthen penalties for this heinous act and equip the public with more information to protect themselves and their families from these sexual predators. Members, the committee substitute simply names House Bill 2000 as Audrey's Law in memory of Audrey Cunningham. That's it. Thank you, members. I'll be glad to answer any questions that you might have.
Thank you, Mr. Ashby. Any questions for Mr. Ashby? Mr. Wood?
I want to be very clear with the committee. The law of grooming is already on the books. So
That's
we're not adding that to the statute. And number two, the statute can only be against children.
That's correct.
Right? So this is not about adults. This is, if you're grooming someone and you're charged with it and convicted of it, it's only for grooming a child.
Correct.
Thank you very much. This is a good bill.
Thank you, sir.
Any other question for Mr. Ashby? Okay, thank you.
Thank you, Mr.
We'll certainly
Chairman.
allow you to close.
I appreciate
And
it.
is there anyone you think we should call as the first witness?
Do you have Ms. Munch, Tabby
We
Munch?
sure do,
She's the grandmother. I would respectfully request that she be called first.
Okay, we certainly will.
Thank
So the chair would call Tabitha Munch. And Ms. Munch, we appreciate so much you being here this morning. And for you and the other witnesses, if you could do one thing for us, and when you begin testifying, is for our record to state your name. If you're representing someone, let us know that, or if you're here on yourself and someone, let us know that. And also, if you could clearly state your position on the bill.
Yes, sir. My name is Tabitha Munch.
Hold the microphone down.
My name is Tabitha Munch. I'm here in 100%. I'm 100% behind this bill. I am her paternal grandmother. I'm here to represent Audrey, who cannot represent herself. I apologize.
Well, you're doing good.
Don't apologize.
My granddaughter was the most loving child I've ever met. She loved anybody regardless what you looked like, who you were. And she loved her animals, any animal. We allowed somebody that we did not know after checking the registry had any kind of a sexual offense of any kind. My life is trying to help people, and in doing so, with checking the registry, my granddaughter was in danger. We never knew. Had this bill been in place, had this loophole never existed, it would never been anywhere near our sweet baby. I'm not only asking, I'm begging that we close this loophole, that we make sure that my granddaughter's death is not in vain. That this bill, I beg of it to be passed by anybody, everybody. This will protect so many children. Because a lot of us check those registries and never know that these monsters are walking free. And I would thank everybody personally for supporting this bill. That's all I can say right now. I close my
Well,
statement.
it's very compelling testimony, ma'am, and thank you for your courage to show up here today and do this, because by being here, you can hopefully help prevent this from happening to some other young person. So thank you so much for being here. Let me see if there's any questions, members. Anybody have any questions? Thank you. Yeah, just thank you so much for being here.
Thank you guys for hearing this. I
Thank-
appreciate it.
Members, next is Philip Munch.
My name is Philip Munch. I am Audrey's grandfather. And basically, today, you've heard from my wife, you can see how devastating this loss was. It was devastating in many ways, both emotionally. Our son, who is here today, he lost his job over it. We know this incident had far-reaching impact across East Texas, our community, the whole great state of Texas. We received outpouring of support from all across the state, all across the country. I mean, it's a case that touched so many hearts. And Audrey was just a charming young lady, lots of potential, and because of a loophole, her life was taken away far too early. And we want to help other children that they don't have to go through this. We know it happens far too often, but once is too many. And we hit that threshold. And we just want to thank you for your support and consideration to pass this bill. We are going to continue to work. If this is a problem in other states, we're dedicating the rest of our lives to help other children. Thank you very much.
Thank you. I need to get you to say, just for our record, that you're here on behalf of yourself and you're for the bill.
I am here on behalf of myself, and I am in 100% support of the bill.
Okay. Do you mind, tell us who else you have here today from your family?
Today, my wife, the two aunts, Susan and Julie, and then we have Joshua Cunningham, her father, and then we have some friends that helped support us during the incident.
Well,
are
we
here as
appreciate all of you being here today. We really do.
Thank you.
Any questions?
Chairman.
Mr. Little?
Thank you, Mr. Chairman. Sir, I just want to thank you on behalf of our committee for coming here to testify about this very important bill. To your point, I think this is a problem in every state. If you spend any amount of time looking into predatory sexual behavior, generally people who engage in that type of behavior start off small. They begin pushing their boundaries. This is child grooming is one of what I'll call the predicate acts leading up to something that is way worse and that your family had to experience it. And it is my sincere hope that the application of this law will make a difference for families like yours. Thank you.
I appreciate it, Mr. Little. What we found is that they are predators. It doesn't matter. I mean, my wife is such kind-hearted. She works with disabled and elderly people all day, every day. And so her heart went out to him. You know, he was in prison. We knew that. We knew some of his background, you know, and we were asked to help him out. And of everyone in the family, Audrey didn't care what he looked like, showed him nothing but love. And to have him do this to her was just unbelievable.
Ms. Jones?
I'm really sorry about what happened to Audrey, but I'm also thankful that you're here and your support system is here to turn tragedy into triumph. I know I'm voting for the bill. I can't imagine why anybody would vote against the bill. And I'm almost certain that as you travel around the U.S. to close this loophole, that people are going to be as motivated, as at least as I am. I think as we are. You judge a society by how well they treat their children and how well they treat the elderly. And we've got to protect our kids, and anybody who preys on kids and grooms kids, at a minimum, they need to be on the registry. So thank you for using this as a motivation so that her loss of life meant nothing.
Thank
And
you.
I'm so sorry.
I appreciate it, and this is just the beginning of our plan to honor her name moving forward. We also want to thank Andy Kahn and Crime Stoppers for helping us to get to this point and help guide us through this process.
Any other questions, members? Thank you once again for being here, Mr. Woods. Appreciate it.
Thank you.
And Mr. Khan is here, and the chair calls Andy Khan.
Morning. My name is Andy Kahn. I'm Director of Victim Services for Crime Stoppers of Houston, and I wholeheartedly support House Bill 2000. I want to thank Representative Jones for her comments just now. They were very touching, and they hit home with not just us here, but I'm sure everyone is watching this as well. When I first began talking with the family after I discovered what happened with her, and I discovered this little quirky loophole in the law, I told them Audrey Cunningham is going to be a catalyst for change. And that brings us here. Child grooming involves establishing an emotional connection with a child to lower their inhibitions for the purpose of sexual exploitation. Grooming is often a precursor to more severe forms of abuse, and recognizing it as a reportable offense underscores the seriousness of the crime. To put it bluntly, if McDougal had committed that crime today, he would have been charged with grooming. But he wouldn't have to register as a sex offender. That's what Audrey's bill takes care of, removes that glitch. So like Representative Jones says, I can't imagine, I get asked all the time, well, what do you think, is this bill gonna, pass? I usually say I'm cautiously optimistic. But frankly, this should be about as a slam dunk as you can get. So let's get this bill out of committee, get it to the floor, get it out of Senate, get it to the governor's desk in memory of Audrey Cunningham. I, like most people here, am sick and tired of naming bills after dead kids. But that's the reality that we have here. So let's honor Audrey Cunningham so that her legacy will last for eternity. And the goal is to prevent more Audrey Cunninghams. This will give parents a tool. And as you heard from here today, if they had known about his past history, which involved a sexually related offense, more than likely they would have not taken him in to be around an 11-year-old girl. This will prevent future Audrey Cunningham. So I want to thank Representative Ashby for his sponsorship and his willingness and eagerness to take this apart. So let's send a message out to the people of Texas, the parents of Texas, that we care deeply about our children, and let's pass Audrey's law. Thank you.
Thank you, Mr. Khan. Any questions, members? Okay. Thank you for being
Thank you.
here. We have Shannon Edmonds. You wish to just, okay. We'll just show Mr. Edmonds neutral on the bill. Okay. Anyone else here to testify for, against, or on House Bill 2000, the substitute? If not, Mr. Ashby, you want to close?
I will.
Okay.
Members, thank you for your time and your favorable consideration of Audrey's Law, House Bill 2000. I respectfully ask for your favorable consideration, and with that, Mr. Chairman, I close.
Okay. Any questions for Mr. Ashby? Members, I don't know of any opposition to this bill, but we do have a couple of members who aren't here right now. I'd like to give them the opportunity to vote on the bill, so we might we will try to pull this bill up later today and hopefully get it out. I'm sorry that we can't do it right now, but these members will really want to vote on this, I'm sure, to have their name on the record to vote for it. So, but it's a bill that we need to get out of here and get passed. And I'm just sorry that we ended up in this. Sorry, we have to pass the bill.
Right.
So,
Thank you, Mr. Chairman.
Any other questions, members? If not, if there's no objection, we'll withdraw the substitute for now, and we'll leave House Bill 2000 pending.
Thank you, members.
Thank you, sir.
Next, the chair would lay out House Bill 1778 and recognize Dean Thompson.
Mr. Chairman, it's delighted to see you and the committee. This
We
is
just wish you were on the committee.
Yeah. I've never been on this committee, but used to be on the insurance committee together. Mr. Chairman, this is another human trafficking bill that we know is one of the fastest growing crimes impacting every continent, every economic structure in the world, even Israel, where Jesus drove the cross. Human trafficking is a problem there. Effectively, we've been fighting this bill here in Texas, and I think Texas leads the nation on its ability and tenacity in trying to stamp out and do something about curbing this crime. We've been fighting this crime, but it requires a comprehensive, coordinated response from all facets of human trafficking prevention, protection, prosecution, and support services. To give you just a snippet of background, the Human Trafficking Prevention Task Force was established back in 2009 under the office of our Texas Attorney General, and is comprised of members from across the state who are charged with developing legislative recommendations, policies, and procedures to assist in the prevention and the prosecution of this horrific crime. This bill is a culmination of the task force's unanimous recommendations to the 89th legislature, and will continue to keep Texas at the forefront in fighting against human trafficking. Specifically, the bill adds the Office of Court Administration to the Human Trafficking Prevention Coordinating Council. It requires body-piercing studios to post signage on human trafficking. It requires human trafficking training for employees of tattoos or body-piercing studios. It requires continuing education for barbers and beauty shops. If there's one place in the world that a person's going to go who are trafficking individuals, they're going to go either to the barber shop or the beauty shop or both. It clarifies penalties enhancements for trafficking a child or a disabled individual, regardless of whether the perpetrator knows the victim's status as such. It reconciles punishment provision for child pornography. It enhances punishment for promotion of child pornography to a first-degree felony for distribution of more than 50 images, videos, or sexual assaults of a child. It extends the statute of limitation for failures to stop or report the sexual assault of a child. It expands protection for victims' outcry statements for all children under the age of 18 or disabled individuals, and it streamlines the definition of disabled individuals and expand the criminal offense of failure to intervene or report any assaulted offense against a child. I have resource witnesses here from the Office of Attorney General. I'm sure the committee would like to hear from them. And Mr. Chairman, I'm available to answer questions of this outstanding committee. And I would like to have the right, reserve the right to close.
And first of all, we know a lot of work went into this bill. It's not just it was months of work went into the bill. The other thing is
2 years.
Especially for newer members to the legislature, you deserve a lot of credit, Ms. Thompson, because you're the one who first started talking about human trafficking when most of the other members really hadn't recognized that it was a problem. And so thank you for that. You kind of got the whole thing going with our statutes to try to do what we could to stop human trafficking. And of course, we've done a lot over the years, but as we know, the problem just has grown out of proportion. It just, I don't think we've had a human trafficking problem in past years like we do now. It just seems to be it just seems to have grown. So thank you for everything you've done. And we just have to keep plugging away and do what we can to stop it. So any questions, members? Ms. Thompson? Okay, if not, we'll go ahead and.
That's all right.
Yes, I'm sorry.
I don't have a question. I just want to thank you for your work on this. It's evident that there's been a lot of work over a lot of time on this bill, and I thank you for your courage and your diligence in getting this to us.
Thank you, Mr. Money.
Okay.
Representative Money.
Mr. Wood?
Can I just say just one quick thing? And again, I want to join Chair Spithy in thanking you for paying attention to this when no one else has, and being the leader on it. And I think this type of legislation is especially important now, especially we're headed towards like what looks like an economic downturn, that the pressure on human trafficking and those kind of things will rise. And the more information our community has, the more tools we have to fight against it, the better. So
We
thank
want to
you.
make sure that the trafficker knows that we are hot on his trail,
Exactly.
or her trail.
Okay. If nothing else, yes, Ms. Jones?
So since this is Women's History Month, I want to celebrate you, Ms. T, as a woman, for focusing on an issue. And I know there are male human trafficking victims, but that there are so many women and girls who are trafficked. And so I just want to celebrate you for, again, being ahead of the curve, and being patient with people to catch up to where you are, because you always sort of seem to know what's right.
Thank you.
Okay. And we'll certainly reserve the right to close. for
Thank you, Mr. Chairman.
Members, the chair would call Michelle Sachs.
Hello, thank you. My name is Michelle Sachs. I'm Executive Director of Street Grace, Texas. We are a survivor-led organization that's working to eradicate human trafficking. So we support the entire bill along with our partners. However, to preserve time, we wanted to limit our testimony to the training of tattoo artists. This is a particularly strategic group to train, as so often tattoos, or branding as it's often called in the trafficking world, go hand in hand. I've been in the movement since 2011. I have spent 14 years training professionals, school staff, community, and even students on signs of trafficking. So for 14 years, we've talked about tattoos and branding being one of those signs. Even though certain signs at times change, this one has stayed consistent for as long as I have been in the movement. So when we look at the prevalence, many victims of human trafficking, especially those involved in sex trafficking, are branded with tattoos by their traffickers. Experts believe that around half of sex trafficking victims have a branding mark somewhere on their skin. The purpose of this is to serve as a designation of ownership and can communicate message of both victims and potential buyers. They are used by traffickers to assert control and deepen the trauma bond with their victims. There are common themes with these tattoos. Oftentimes you see names or initials of traffickers. Sometimes you see distinctive symbols such as weapons. Other times you see depictions of wealth such as barcodes, currency symbols, and money bags. And then themes of just money and loyalty. So when you look at the location, many of them placed in highly visible areas. What I've seen in my line of work are on the neck, somewhere on the face, and even on breasts. And then sometimes the locations are hidden to where you can't see them. The presence of unusual tattoos in a typical location might prompt consideration that the individual is a victim of human trafficking. However, we also want to note that just having a tattoo alone is not a sign of trafficking. We know that tattoos are very, very common in the general population. So my prior work as a forensic interviewer working directly with victims of trafficking, I can tell you that branding tattoos have significantly affected survivors' mental health and can impede their healing process. Many survivors report physical and emotional pain associated with these markings, especially if they're out of the life trying to find jobs, and also just that constant reminder. We wanted to share one story as I wrap up. We had a 14-year-old girl who was being trafficked, and if she earned her quota, she was going to get a tattoo that she had designed herself that had rainbows and butterflies. She fulfilled that quota, sleeping with numerous men a night, and got what she thought was a tattoo at the base of her back. But when they finished and she looked in the mirror, the tattoo said cash only. After being recovered by law enforcement, with the help of nonprofits, she was able to get that tattoo removed. I should mention that that's also a hindrance too. It's expensive to get them removed. So therefore, again,
Well,
it
we
just
appreciate
prolongs.
your
It prolongs the
testimony.
healing process. But thank you so much, and I also want to say thank you to Representative Thompson for working so hard on trafficking for all these years. We're out on the streets doing the work, and knowing that we have the support of Representative Thompson here at the Capitol is definitely very helpful.
Any questions for Ms. Sachs? Thank you for what you're doing. Appreciate you being here today.
All right, thank you.
We have Alan Place, former member.
Mr. Chairman, members, my name is Alan Place. I'm here on behalf of Texas Criminal Defense Lawyers Association on the bill. 99% of Dean Thompson's bill we're more than fine with. There's a couple of issues we pointed out to her at the end of the bill. One has to do with a shall to a may, and the other one is an evidentiary section that we believe is a little bit broad, but we'll continue to deal with Chairman Thompson's office, and if there's any questions, I'll be glad to go further if need be.
Any questions?
Mr. Smithy?
Little?
Yeah. Mr. Place, thank you for raising those important issues. Would you please highlight for me the sections of the bill that are of
Sure.
concern to you? The shall may, I hadn't stumbled upon the shall may portion that concerns you, but I'd like to talk
Hang
about
on
it.
just a minute. I'm going to have to see this, and it may take a second. The three things that we had written to Dean Thompson is the penalty, reconsider the penalty under 3.02. The second one is under 4.03, it's a shall to a may. Our concern there is the shall as written would remove a judge's discretion and would have to admit it. A may is, as you know, there's a little bit of difference there in terms of how you can proceed. It would allow that, but it would certainly have to be proven. The last one.
Can we stop there real quick?
Sure.
So the section 4.03 that you're referring to is section 4.03 internal to the bill, not relative to the Code of Criminal Procedure or
To the bill, I'm sorry.
Okay,
Yes, sir.
I had, the concern that you're raising is of similar concern to me. This is a wonderful bill that touches on many important things. I do have some concerns about the expansion of the use of extraneous offenses in criminal cases.
That's my next one, yes, sir.
So, obviously you're testifying on behalf of TCDLA.
Yes.
What's TCDLA's position with regard to the expansion of the use of extraneous offenses?
The circumstance that I'll get to that in a sec. 4.03A1 is just where we think it should be shall to may. It still would allow any number of statements, but it would give the judge discretion to make sure that the bar has been met to admit that. In regards to section 4.05, I think there's a number of things that I would state. One is it certainly broadens the current law in regards to extraneous offenses. Number two, the intent of the bill, of course, is trafficking, and that's why we haven't had an issue with 99% of it. In terms of being too broad, it's not just related that section evidentiary is not just related to trafficking. It's certainly much broader as written, so hopefully there's maybe a way forward is what we're trying to say.
Well, Mr. Place, I share your concern. The bill accomplishes some very important modifications to the law as it relates to trafficking, but it is, in my view, way more expansive than that as it relates to criminal jurisprudence. I think that the ongoing expansion of this extraneous offenses piece tends to corrode some of what we were taught in law school as far as not using those to prove other bad acts. But the trend that I see in the legislature is the legislature in Texas seems to be expanding the use of extraneous offenses kind of one by one. And this represents a significant expansion beyond child sexual abuse, which is typically subject to pattern evidence. I mean, with child sexual abusers, typically you're going to see a person who abuses not just one person, but maybe 10 or 20 or 50 people over their life, someone who is a true sexual predator and is part of a plan or scheme, versus other types of offenses that are implicated here. For example, so when we're looking at Section 4.05 of the bill, we're striking out if committed against a child under 17 years of age. So my understanding is if this bill were to pass, that any evidence of any past sexual offense would be admissible in any case involving any sexual offense, regardless of age.
That's correct.
Do you read it the same way?
I do.
Okay. I do have some concern about that, but thank you for raising it.
Thank you.
Okay, Mr. Cook, okay. Ms. Jones?
Hey,
Good morning.
as a card-carrying member of TCDLA, I'm glad to see you here.
See you.
I just want to be clear, I understand something. You're looking at, can you see the pages? I just want to make sure I'm following. Your section 4.03, you're concerned with the court shall admit. And you want
Yes.
that to be made, correct?
I think it still gets to the purpose of the bill if it's made. That's my opinion. Yes, ma'am.
Okay, and then on 4.05, which is right down the page, actually, you're going to page 27. You want the if committed against a child under 17 years of age re-put back in there? What do you,
Current law applies, as Representative Little said, to 17 and under, and there's logic, in our opinion, as to why that's the current law. Okay. We would just submit the current law we believe addresses best the situation.
so you want to just leave that in, or you don't think we need this section because it's already addressed?
Our suggestion in terms of how you read the bill would be to strike section 4.05. That's our initial suggestion, barring further talks with Chairman Thompson.
So you want to strike section 4.05?
That's correct.
Okay, I just wanted to
Sure,
make
understand.
certain what you wanted.
I
Thank you
understand.
so much.
Thank you.
Any other questions? Okay. Thank you, Mr. Place.
Thank you,
for
Mr.
being
Chairman.
here. Is there anyone else here to testify for, against, or on House Bill 1778? There appearing to be none. Ms. Thompson, if you want to close.
Mr. Chairman, thank you very much, and I close.
Okay. And I understand you're working on a substitute, maybe, and you'll kind of visit with Mr. Place and, oh, yes, Mr. Moody.
And it's not a question, but more a comment, and kind of pivoting off of what Chairman said. I know you're working on some of the language. I've talked to some prosecutors about Article 3 of the bill covering child pornography. In the past, what we've done to increase the punishment for those types of offenses, we say, well, the number of images you have is how we're going to track that. We've started to get away from that a little bit and moving towards what's contained in the image, right? And so, and this bill does that. It ratchets those numbers down and creates the penalties higher. I know that grand juries, our petit juries, our prosecutors, if you're going to prove up one of these that have multiple images, I mean, all of those people have to view them. They have to see them. And I think there is maybe an I don't know if you've heard some of these topics in comments and concerns. Perhaps there is a way to get away from the way we've done this in the past, which is basing it off of number of images and moving more towards what is contained in the pornographic image or video. And so we've done that in some respects, and I think maybe there's a way to do it. It could certainly, I mean, truth be told, any one of these pedophiles that has these things has a phone with thousands of these images on them. That's why you've ratcheted these numbers down to increase the penalties. So just a conversational point, and I'm happy to visit with you offline. I know there is some philosophy to look at getting away from the number of images and getting to maybe what is being depicted there, because that is, it's to go through a prosecution of multiple images. I mean, you're going to visit a trauma on the jurors, the prosecutors that do these cases, and maybe there is a way to address that based on the severity of the conduct that's contained in the image.
Well, you know, my part to the freshmen as well, I have an open door policy. I don't ever get offended by my legislation. I'm always willing for, if it can be improved, good, I'm ready for that. And you're always welcome to come into my office. I can come to yours and we can work, see what we can work to improve the bill. The name of this particular game is to make sure that we stop these people. And in stopping those people, we don't want to perpetrate on the rights of others.
No, and I agree. And my commentary is not on whether that section is sufficient. I think it's a move in the right direction. I just had some conversations with some folks that are involved in these types of prosecutions and wanted to explore that as a possibility. So thank you so much.
Thank you.
Ms. Bowers?
Thank you, Mr. Chairman, and thank you, Ms. Teague, for this piece of legislation. I'm interested in the September 2025 start or implementation date. Just wanting to know, with the urgency of these issues, what led you to that timeline and maybe not picking an earlier effective date?
Well, you know, when we implement laws and we have several agencies involved, we need to give them some time to catch up to.
That's fair. Thank you so very much. Thank you.
Right. Anything else for Ms. Thompson? Okay, appreciate you being here today, and we'll look forward to continue working.
I'm delighted, and I want to thank the committee for hearing this piece of legislation.
Certainly.
Excellent piece of legislation.
Certainly. So if there's no objection, members will, the chair
And I
will-
look forward to Mr. Little coming by and helping me on that.
Yes, Ms. Thompson.
Okay, thank you.
The chair will leave House Bill 1778 pending.
Thank you so much.
Mr. Metcalf, are you ready? Yes. The chair would lay out House Bill 2596 and recognize Representative Metcalf.
Thank you, Mr. Chairman, members. Good to be with each and every one of you this morning. Under current state law, victims of sexual or aggravated assault are granted access to a protective order under Article 7B of the Code of Criminal Procedure. However, if someone breaks into your home with the intent to commit sexual assault or aggravated assault, the victim is not entitled to a protective order. House Bill 2596 expands Article 7B of the Code of Criminal Procedure to provide protective orders to victims of home break-ins with the intent to commit sexual or aggravated assault. Protective orders are essential for safeguarding victims of burglaries, particularly in cases where the perpetrator has attempted assault, as such orders provide immediate and critical legal protection. In instances where an individual has unlawfully entered a residence with the intent to cause harm, the risk of further violence remains high, and the safety of the victim is compromised. A protective order serves as a preventative measure, legally prohibiting the alleged offender from contacting or approaching the victim, thus mitigating the potential for subsequent violent acts or intimidation. The issuance of such orders not only ensures the physical security of the victim, but also upholds their right to live free from the threat of harm, fostering an environment for safety and justice. Members, let's ensure that victims of break-ins where a perpetrator attempted sexual or aggravated assault are granted the right to obtain a protective order. Thank you, Mr. Chairman.
Okay. Any questions? Mr. Wu has a question.
Okay. I understand exactly what you're doing.
Good.
Why not just make it burglaries? If somebody just breaks into your house, they know where you live, and if someone, it doesn't, and even, again, and the more that the point is, I think the way this is drafted up, you would have to there would have to be some kind of finding or prove up of the sexual assault or the attempted sexual assault. I think that's kind of hard.
Okay.
And I would say, like, I'm worried that the people who would actually need to use this wouldn't be able to use it because they wouldn't be able to meet the requirements of, like, because if somebody's been arrested for it, the DAs may not want you to put out all the evidence of, hey, this is what we're going to use against them to prove up the attempted sexual assault or the burglary, and that. But I think if you just make it burglary, it's a felony. You're breaking into someone's house, and even people who were not like attempted to be sexually assaulted might still like, hey, I don't want this guy back at my house. Then they know where I live. Just throwing it out there.
I get it. I understand. I would like to defer that to one of our witnesses here today, if that's okay. And I fully understand where you're coming from, though.
Any other questions?
I'll
Mr.
just
Little?
say that I mean, Representative Wu's point is well taken. It's very difficult to establish someone's intent after they've committed a burglary. Obviously, they're intending to do something illegal when they get there, which kind of satisfies the predicate or the elements of a burglary, an entry into a dwelling with an intent to commit some other offense. But it's very difficult to dial in on what they intended to do when they get there if they were interrupted and arrested in that purpose. So I think, Chairman, Representative Wu's statement is well taken, that the bill may have more effect if that subsection dealing with committed the offense with intent to commit an offense listed in subdivision 1 of the subsection, if that part is stricken, I'd certainly consider that as well.
Understood. Thank you for the feedback.
Ms. Jones?
Thank you for bringing this bill. I actually agree with Rep. Wu. I've had my house broken into, and the truth is, you never have peace anymore. Especially if you don't know who did it. And the one place we should feel safe is in our homes. So, I mean, if you changed it, because I don't think that it's that just because you break into my house because you want to do something sexual to me doesn't mean that if you just break into my house, I'm still not terrified.
Understood.
Right.
Yeah.
So, and sometimes you may break in to do something and it goes really wrong and really bad, and the next thing you know, I'm dead, and then there's a capital murder. So I just don't want people at my house.
Understood.
Or anybody else's house.
Agreed.
Thank you.
Thank y'all for your feedback.
Mr. Money?
I'm going to belabor the point just a little bit more. No, I appreciate everything everybody said, but as I was reading through this, and I think it's a good bill. But I would think that most of those people that apply for a protective order under the subchapter, or they apply for a protective order, are doing that against someone that they know and they've had prior contact with, usually a family member, someone like that. And I don't care if that person broke in to apologize. If they break in to apologize, to Ms. Jones' point, that's a terrifying thing. That turns into that. So if we've had an altercation and you've broken into my house for any reason, after that,
it's a problem.
I think we need to allow for a protective order there.
Absolutely. Thank you. Thank you, Mr. Chairman.
Any other
members.
questions? Good. Thank you, Mr.
Thank you.
Metcalf. And so Chair calls Britt Ligon. Ligon? I ought to know that, I'm sorry.
Good morning, sir. How are you? My name is Brett Ligon. I'm the District Attorney in Montgomery County. We are the county immediately north of Houston. The small city where I'm from, Montgomery, Texas, is otherwise known as the birthplace of the Texas flag. We have the Woodlands, Lake Conroe, and steer communities like Cut and Shoot, Texas. So that's where we're from. We had asked Representative Metcalf to file this bill based upon a case that had occurred within Montgomery County, but listening to Professor Jones, Wu, and Little, I believe, I'm in complete agreement. I was here to defend a narrowly tailored addendum to the protective orders, but I believe that Vice Chair Wu and Committee Member Jones have struck the nail on the head. When you burgle somebody's home, the way that the statute currently is, it's not just to commit a theft, right, which it was when you and I were in law school. It's been amended to also include assaults and to include sexual offenses as well. So these are all first-degree offenses by themselves, and so I do agree, as amended, issuing a lifetime protective order against somebody that has committed the offense of burglary to protect somebody's home, because we don't expect the victim to have to move out of their own home just to remain safe in their domicile. So I agree with the provisions, and I will quote Ms. Thompson earlier, this is a beautifully crafted piece of legislation. With y'all help, I think it got even better.
Any questions? Mr. Wood?
And I think, I don't want to beat this point to death, but again, like, I think to Rep. Jones's point, like, dude, if somebody broke into my house, it would make me feel a whole lot better. I know that that person might be in jail, or they might not, they might get out at some point. I would feel a whole lot better if there was just something that says, hey, by the way, even after you get out, don't go anywhere near there.
Well, and to your point, regular burglary is 2 to 20. If it's one of the aggravated offenses, it is a 5 to life. But oftentimes, if you're dealing with an offender that has a long period of life left, say it's usually a domestic violence relationship, or as you indicated earlier, these are usually burglaries where somebody knows somebody. They're the known assailant. And so the lifetime protective order would extend even beyond the period of deferred adjudication or beyond a period of incarceration. But the statute as exists does allow those people to petition the courts to remove the protective order at some time in the future. So all that is already in the statute. So I believe it does protect everyone with y'all's addendum.
Make the prove up a lot easier.
Thank you.
Anything else? Ms. Jones?
I also like that the victim doesn't have to go and try to pay for a protective order in protective order court, right? And then you don't always get a lifetime protective order.
Correct.
I know that the MOEPs actually, and that's the emergency order of emergency protection for those of you who don't know what that means. I know you know, but this is for the listening audience. That it's like 61 days or something. So when
61 days if it involves a weapon, 31 to 91 otherwise, but can be up to 91.
Right, but my point is this. I cannot tell you the number of clients I'm like, this over in 61 days, or this over in 91 days. Well, so I still don't want you at my house.
Exactly.
So, and so a lifetime protective order, I think is important because it also accounts for, if I have a lifetime protective order just by you coming into my house, if I move and you are ticked at me because I helped prosecute you, if I move somewhere else, you can't come to me either.
Correct.
And go there. So I'm glad to see that. Because as I will say before, to this day, when I go to my house, I keep my head on a swivel. For those of you who don't know what that means, because it's Ebonics, I'm looking around because my house has been broken into, right? And I just want to make sure, and when I get into my house, I lock the door and I turn on all the lights and I go check it. Before my house was broken into, that never happened. It never occurred to me that someone would invade the most personal and private space that I have.
Yes, ma'am. I understand.
Okay.
I agree and agree.
Any other questions for Mr. Liggett? Okay, appreciate you being here.
Thank you.
Is there anyone else here to testify for, against, or on House Bill 2596? There being no one, Mr. Metcalf, if you want to close.
Thank you, Mr. Chair, members. This is a pretty bill. We'll make it a beautiful bill after y'all's, after your feedback. We'll come back with a committee substitute. That's okay.
One thing that you might do, in fact, I'd recommend doing, is checking with a parliamentarian to see if broadening this bill might cause you some parliamentary problems. I don't think it does, but it's probably a good idea to just run that by the parliamentarian. We don't want to kill your bill.
Absolutely.
And so.
Thank you, Mr. Chairman. Members, I close.
Any other questions, members? Okay.
Thank you
you very
for your
much.
feedback.
And so if there's no objection, the chair will leave House Bill 2596 pending. Ms. Gonzalez, you ready? Okay. The chair would lay out House Bill 449 and recognize Representative Gonzalez.
Thank you, Chairman and Vice Chair Wu. So there's currently a loophole in legislation that must be addressed. Last session, we did legislation when it came to the creation and distribution of sexually explicit videos when it comes that are being made by AI, but the law only said videos. So we're just trying to close the loophole to also include photos because if you read some of the news stories, like I'll give an example, a teacher was taking pictures and making deep fakes with the students' pictures. And so it was just, but because it was pictures, not videos, we weren't able to use this part of statute to address that. So we're just closing a loophole. It's pretty self-explanatory. Y'all are the experts. This is a really intimidating committee with all y'all lawyers. I'm just a professor/farmer. So, but with that being said, I request favorable consideration and reserve the right to close.
Okay. Any questions for Ms. Gonzalez? Thank you very much.
Thank you,
I'll go ahead and
Chairman.
call Adrian Shelley.
Thank you, Mr. Chairman. Members, Adrian Shelley with Public Citizen speaking in support of House Bill 449. I've got some testimony that's going around, just some general statistics about the issue. I'll be brief. The use of artificial intelligence to create deepfakes has exploded in recent years. Just from 2022 to 2023, there was a tenfold increase in the production of deepfake videos in particular. 99% of the victims of the creation of intimate deepfakes are women, and a majority of them are children. It is also fairly common in our schools. As many as 1 in 15 students reports that they or someone they know has been a victim of a maliciously created deepfake. It is also true, a study just a couple of years ago found that 75% of the time people cannot tell a well-produced, good quality deepfake from an original. This bill, as we heard, just adds images to the existing crime of unlawful production of sexually explicit material, and for that reason, we're supportive. Thank you.
Any questions, members? Okay. Thank you
Just
very much.
Real
That's right,
quick.
Mr. Little.
When this, I'm sorry I didn't happen to be here when this was signed into law previously. Why was it just originally limited to videos?
Yes, sir, thank you. There were a number of laws that were passed, including one related to elections, and for whatever reason, they all started with just videos. There have been a couple of instances now of an image that was produced that would have otherwise fallen under one of the Texas's new statutes. We're one of 31 states that has statute now. So this is just an update for what was presumably an oversight in the original legislation.
Thank you for that clarification.
Thank you.
Anything else, members? Okay. Thank you very much
Thanks,
for
sir.
being here. Is there anyone else here who wishes to testify for, against, or on House Bill 449? If not, Ms. Gonzalez, if you want to close.
Thank you, Chairman. And Representative Little, just to answer your question, I can't fully answer it, but Senator Huffman was the original author of the bill. We have been working with her office. She's picking up on the Senate. So I think it really was just an oversight because they're not opposed to that change.
Thank you.
Of course.
And so, as far as you know, is there going to be a substitute?
The committee, I mean, it's pretty self-explanatory.
Okay.
I don't think there'll be a substitute,
Okay.
but we're happy to take any feedback. Again, not a lawyer, so if y'all who are much more brilliant than I am, I will gladly take your feedback and advice. But ultimately, we do want to protect women and young children who are being victimized with this type of technology, so.
What happened the last time you took the word at this committee?
Yeah, so, yeah. So, anyways, okay, well, but I don't think so. As of now, we
Okay.
haven't heard anything.
Any questions?
Okay.
Thanks very much.
Thank you, Chairman.
So,
Thank you, everybody.
Members, if there's no objection, the chair will leave House Bill 449 pending. Ms. Johnson, you ready?
I am.
Okay. Okay. The chair will lay out House Bill 324 and recognize Representative Johnson.
Thank you, Chairman Smithy, Vice Chair Wu, members of the committee. I appreciate very much the opportunity to present House Bill 324, or also known as the Summer Willis Act, who you will hear from this afternoon. The bill addresses critical gaps in our sexual assault laws, specifically around the issue of intoxication. Sheriff Louderback, I'm sure you are aware of that phrase of fight or flight, that you never know how people are going to react or respond in a moment of that kind of attack. And Representative Little, when you were before Civil Jurisprudence, you made this powerful statement with regard to victims of sexual assault and described it as soul murder. And we are seeing, unfortunately, in Texas, despite our efforts in the penal code to deal with the issue of consent, The Sex Assault Task Force Advisory continues to tell us we are not giving prosecutors the tools that they need to deal with the issue of intoxication or lack of consent to a point that can hold a perpetrator accountable and not put them in a position of effectively derailing the prosecution. Today, you're going to hear from Summer Willis, who has experienced sexual assault and rape, and she is going to tell you about the years of which she has made it her mission to tell people the trauma that victims come through and the fact that Texas does need to update our laws. You're also going to hear from Jana Oswald, who is absolutely an expert in this field from Harris County. She is on the ground in the courtrooms dealing with the challenges of these prosecutions to talk about the manner in which this bill addresses three critical issues: the incapacitation and consent, withdrawal of consent, and impersonating trusted professionals to obtain consent. Chairman, I'm happy to take any other questions. Ask that the committee gives a chance to these two witnesses and reserve the right to close.
Any questions? Mr. Little?
Thank you, Chairman Smith. Representative Johnson, I asked these questions with great temerity, understanding that this is your area of expertise. I spent a lot of time with this bill last night trying to really understand its effect, and the portion that I'm trying to really understand the most is dealing with what I'll call the rewrite of the mental state provisions within sexual assault. And one of the changes that your bill seeks to make is that the aggressor knows or should have known that the victim was incapable either of appraising the nature of the act or resisting the act. And I can understand how that would, how that provision would be engaged if the victim were drugged, too drunk to know better, somehow otherwise incapacitated. I'm looking at that provision and wondering, what is the real life on the ground application of incapable either of appraising the nature of the act or of resisting the act? What, in your experience, what are we fixing there?
I appreciate the comment, and actually what you bring up is probably the issue that we've dealt with for the last couple of sessions, that the House continues to pass this bill, but the Senate doesn't even take it up. And what we're asking for is reasonably should have known. And so, as most are aware, in criminal law, we can't make the defendant confess. We can't make them give us a statement. And how do you, as a prosecutor, prove that the defendant knew if the defendant doesn't confess? And so what we're looking at here is the circumstances of the facts to show that the defendant reasonably should have known based on the fact pattern is there. And part of this here, and you've seen this recently in the news, with individuals that are intoxicated and have a question of whether or not they have withdrawn consent or have not, and you've had prosecutors say, hey, I can't make it fit into the existing provision or statutes of consent to let the jury make the determination. And you're right, Representative Little, part of this is, and I do have a prosecutor here that can answer on the ground examples of where it's happening. The problem that we're seeing is, despite prosecutors' best efforts to address the issues of the victim, to get it in front of a jury, for them to make the case-by-case determination under the facts, if it was a circumstance by which a reasonable person would have known that they either withdrew or didn't have the capacity to consent. When you flip that into not what we can see the defendant should have known, but that the state has to prove what the defendant knew, it puts all the power in the defendant.
I see your point. The other thing that I looked at with some great interest was the modification to the call them vulnerable persons provisions. You're pulling within the ambit of the statute people who impersonate a public servant, impersonate a clergyman, impersonate a coach or two. Does that happen?
Yeah, all the time. I wish that wasn't a real thing, but there are lots of folks that like to walk around and pretend to be cops or pretend to be other clergy or anything else. And so when people think that they're effectively giving to consent to somebody that's an authoritative figure, and I've asked the same question, why don't we just allege fraud and that there wasn't really consent? So I would liken this to like aggravated assault deadly weapon, where by statute we say if you have a gun, if you have a knife, you don't need to prove any more than that. The jury can make that determination. We are effectively, as a state, saying if you are impersonating this individual or authority figure, it has the same effect.
Yeah.
And so we're trying to shut off the fraud.
And but the problem is that if this were an actual clergyman or an actual mental health services provider, the liability is automatic. Whereas if you're just saying, well, I'm not actually one, I'm impersonating, you don't fall within the ambit of the statute yet.
You mentioned liability, and so when you say that, I think of civil. So I want to make, we're still talking.
Criminally liable.
Yeah, criminally responsible. So yeah, what we've done is the one thing I can tell you about perpetrators, they will pick the vulnerable group. Whether it's in a church camp, whether it's in the mall, a perpetrator knows how to pick a vulnerable person. In many circumstances, vulnerable people may come before clergy, other healthcare professionals, and they're there seeking support and advice. That's the kind of relationship by which that other individual has some ability to not only display, and we've heard it, we've heard about religious individuals that have indicated, I've heard about it to married spouses, that having sex with them was going to better enforce their relationship with God. Now, that sounds shocking that it would come from somebody that is trying to portray themselves as a man of God, but those are real scenarios. And so we're just taking that one level further, that for the people that are perpetrators that know that that important relationship with somebody like a counselor or a clergy or a coach or a tutor is somebody that gives you a pathway of trust, that even worse, if they're impersonating that pathway of trust to get them to comply with sexual assault, we're not going to give them that get-out-of-jail-free card.
Okay. Thank you so much for those clarifications.
I appreciate it. I reserve the right to close unless there are other questions.
Ms. Jones had a question.
So I was trying to follow the conversation. I actually like the little tag team thing that Rep. Little and I do, but I was trying to follow what you're concerned about, because I'm a detail freak. So can you just tell me where you were looking that concerned you, so I can just have that for my notes?
Let me turn my microphone back on. Excuse me. So this is the modification to 22011B of the Penal Code. So as we're...
The page and
I'm sorry, I printed it in a letter. I imagine it's going to be on one or two.
So
but
Representative Little, if I remember, it was the impersonation? And
no, the major the concern that I had was beginning with B3. It says the actor knows or reasonably should know. I have no problem with or reasonably should know. The other person is unconscious, physically unable to resist. And then C, incapable either of appraising the nature of the act or of resisting the act. And I'm trying to understand what that means and what its application is here, because the way that I read C, incapable either of appraising the nature of the act or of resisting the act, or D, unaware that the sexual assault is occurring, I see that as a significant expansion of the, I call it,
so if I
aggressor's mental state.
So the concern is the mental state of the victim. So if the victim has been drugged, right? So if you have been drugged to the point that you can't either physically respond, verbally respond, we're dealing with those scenarios of where any individual in some circumstances are incapacitated by another, where somebody else roofies them and then somebody else takes advantage of them. That's a circumstance where it would be almost impossible for the state to prove under the existing statute.
And can I ask a hypothetical that I think would be relevant? So you have an assaulter who assaults a victim. The victim says, I was drunk. Anybody would have known I was drunk. And the person who's been charged with the offense says, well, I was drunk too.
Yes.
And so is that person possess the appropriate mental state under your proposed change, and is there a difference from the current state of the law in that regard?
That's a great concern, and it is one that I've also thought about, and I will say there is a big difference between regret and rape. And that's why you want good prosecutors with the tools to be able to evaluate those facts and make decisions. But voluntary intoxication is not a defense under criminal law. That's why DWI is a crime. You go out and drink too much and drive a car and run somebody over. We don't allow you the defense to say, I'm sorry, I was drunk. If we don't allow the defense in hitting somebody in a car, how could we equally allow them effectively to say that on rape? And that's part of the challenge. It's not a defense under the law. But it's currently, because of the state of the victim and their intoxication, effectively becoming like a get-out-of-jail-free card for the perpetrator.
That's what I was wondering. Thank you,
You're welcome.
Representative Jones.
Thank you.
Sorry.
So you said something that I now have a question about. You said if you're incapacitated by another.
Right now, we're not catching that.
Right. So that's somebody roofies me or something like that.
Or one person roofies you, another individual takes advantage of them doing the act of incapacitating you and taking advantage of you.
So I've got two questions. The first question is, how do I know if somebody roofied you? Like let's say you're roofied.
Yeah.
And then I do something to you. How is there a requirement that I know they roofied you?
No, and that's why you're looking at if a reasonable person in this circumstance would have recognized this was not somebody that should have been sexually assaulted. This is not somebody that was consenting. And that's why the challenge is, it really is about giving prosecutors the tools to have available in a fact-by-fact situation to be able to have the leeway to be able to get this into a jury.
Then another question, why does it matter? Like, let's say the person drank too much and they're literally incapacitated, right?
And they pass out on the
And
floor.
they pass out on the floor.
That cannot be implied as consent.
There's no consent.
Okay, I just
Right?
was,
So,
okay.
and the question right now is, we are putting too much of a burden on the victim to somehow prove that they didn't consent. We're trying to shift this to recognize, just because you see a drunk college student incapacitated at a frat party, that doesn't mean you can.
Say it's easy pickings.
And that's the point. It's easy pickings. And right now, despite the fact that Texas has tried, and we've got some laws around the issue of consent, we're not capturing the full breadth. And I will say, just like we do we saw Ms. T come up here every 2 years on human trafficking, I hate to tell you, perpetrators, when they figure out there's a loophole they can exploit, they for damn sure exploit it.
That's right.
Okay. I think I understand. And if I have any more, I'll just come
Please,
to you.
and we have this amazing prosecutor here today that can answer this stuff better than I can.
Mr. Money?
Thank you, Ms. Johnson. Thank you for working on this important issue. I think over the last 15 or 20 years, this is one of the scariest scenarios that I read about in the news. Thankfully, I'm not in criminal law, so I don't have to prosecute or defend cases like this. But there's horrific stories on both sides. And so I'll use Representative Little's word, temerity. I'll step into this not only because of my lack of legal experience, but just the sensitivity of the topic. And my concern here is I've got layers of concerns on both sides because I want to solve the problem that you're solving, and I don't know where I am exactly on this bill yet. But ultimately, a judge or jury is going to have to prove beyond a reasonable doubt these things. And so you back up and you already have a situation in which if a crime occurred, it occurred in an intimate setting where usually there are no other witnesses or any evidence other than the defendant and the victim explaining what they think happened. You have usually in both cases alcohol. I appreciate what you said about voluntary intoxication. That's true, and I would encourage everyone to not go to the frat party and get drunk and look to carry some, to go home with someone. But in that case, you have alcohol. You have consent, which in intimate settings, whether there's alcohol involved or not, is sometimes murky, and it can be given and withdrawn at various times. And then you have a knows or reasonably should have known standard that it complicates it even more. And so all of that being said, I do not want any young woman to ever, or old woman or person, to be taken advantage of, whether they have had a drink of their own volition, have been slipped something by someone else. I mean, people should be protected from sexual violation in every respect. I also don't want someone to be accused and convicted of something that is
I get it.
difficult
Keep going,
and
but I get it.
murky.
Yep.
And so I want to know, and I know this may be for the prosecutor that's going to come up and talk, like in real life, in real situations, how do we know that this gets us somewhere where we have him saying, I didn't know that she withdrew her consent. And she says, well, you reasonably should have known that I withdrew my consent. And he says, that's not the way I remember it. I mean, does this really even get us closer to anything that we can prosecute beyond a reasonable doubt?
I do, and I'm going to have the prosecutor speak to some of those examples. When you ask me this question, I feel the same pull that I felt with Representative Little, that I don't want a pendulum to swing so far the other way that, I mean, well, let's just look at the power dynamic here. We are typically talking about women as victims, male as offenders, but that's not always the case, right? And I don't want that to be where, you know, we all think about college and the rite of passage of the drunken parties and everything else, but we can't make the rite of passage also rape.
Right.
And so part of the challenge here, when you said intimate settings, also people hold people up in an alley where there's no witness. And that's part of it. These are not always intimate settings. Sometimes these are settings that the perpetrator puts in place that there is no witness, there's no ability to have a witness, and you are taking their word versus the other. Or we are seeing the manner in which people are being incapacitated. I will tell you one other story. When I was a prosecutor and somebody was insisting that they wanted a case filed, they had met up with somebody when the internet was new. They had gone to this gentleman's apartment. They had taken a bath in his apartment. Those people ended up having sex. A couple days later, he hadn't called. She talked to a coworker, and a coworker said, well, maybe that's rape. That's not rape. That's regret. And I am very mindful. I do not want to do anything here that would allow for false accusations of rape to be equally taken advantage of. I do trust many of our prosecutors, and all I can tell you is, unfortunately, right now, despite our best efforts on the consent language and based on our sex assault task force, we are missing a component of perpetrators that are now taking advantage of our failure to fix this in the law. But I do want our prosecutors to have tools. I don't want them to have a weapon that shouldn't be used in a bad way. And so I'm happy to talk to you about it. I get it, but it's also why the law requires 12 individual people unanimously to determine that they believe beyond a reasonable doubt. That hesitation or that question that would benefit the defendant, I do believe is built into our standards. Not saying I want to take advantage of that by any means. I just know we have something lacking, and I'll be happy to answer more after the prosecutor gets a chance to talk about some of the scenarios that we're seeing, if that's okay.
Okay, thank you.
I appreciate it.
Vice Chair Wu had a question.
Hi.
Could I, do you mind if I run a scenario by you?
Sure.
Okay, so let's say.
If I can't answer it, can I leave it for
Yeah,
Ms. Oswald?
absolutely. I think you will be, though. Let's say an elected official has a staff and has a lot of young staffers, and that elected official invites a young underage staffer.
Go ahead.
And that person plies them with alcohol, has them drinks themselves too, but plies them with enough alcohol that they are obviously intoxicated and unable to consent, and they have sex, right? Would that scenario fall into, like, this law?
Well, I have to say, until you raised that question, I had not thought about that scenario in this particular circumstance. The question of whether or not there's an issue or lack of consent is always a question, and that's why I think people need to be able to have the tools to determine. And so all we're doing here is making sure that prosecutors have the opportunity to evaluate each case on the merits.
But
Thank you.
thank you.
Thank you. So is
Thanks,
there anyone
Chairman.
you want to call first as a witness? Oh, I'm sorry. Ms. Jones?
When I had intended to ask you something, when you first started your layout, you said there were 3 issues. You said incapacitation, withdrawal of consent, and what was the third one?
The impersonation of a person that's a kind of trusted authoritative figure.
Okay,
And that's why
then-
we created the impersonation, as opposed to you are one, you're making people think you are one to garner their trust.
And then the next question I had was, you're shifting the burden from,
Not shifting the burden, I'm acknowledging the fact that where we currently are, where we have to prove that the defendant knew, that puts all the control in the defendant, that if they don't confess, how do you know that they knew? How do you prove that they knew in that, quote, intimate setting where there is nobody else? And that's why the knew or reasonably should have known allows an opportunity for a jury to look at a broader fact pattern as opposed to putting the onus on the defendant to admit that they did wrong or not.
okay, so I just want to make sure, rather than say intentionally, what does it say, intentionally, knowingly, and why can't I remember the
It
third
says
one?
new. So if you
No,
look
no,
at
no,
the
I'm saying,
statute,
right, no, I'm saying just, in most criminal cases,
Yeah.
it's intentionally, knowingly, and.
you still have intentionally knowingly commit the
Right,
act. What we're
right.
talking about is the breakdown of the
They knew or
subsections that
should
talk
have
about
known.
consent.
Okay,
So we're really talking about the sections that we already have there on consent, where it effectively says that the defendant knew that there was a lack of consent. We still have to prove intentionally knowingly committed the crime. It's just that knowing of consent element as to the individual saying, I didn't know, or not confessing.
so you cleared it up for me.
Okay.
Thank you.
You're welcome.
Yes, Ms. Moody?
And I did, to crystallize this, and this has been a conversation we've had for several sessions, I think going back to 2017 now. And to your point, Representative Johnson, the conduct we're talking about, and I mean, obviously anybody can go read the code provisions about the actual physical conduct we're talking about. In these instances, and what you've got in your amendment going to be Section B that refers back up to A1 is where we're going to say consent doesn't exist. Now, there's still evidence that's going to have to be proffered to any of these points where you're saying that consent cannot exist in this circumstance. So it made me think of you have this, because you've got the provision about if the person is, let's see how you have it worded, the intoxication, right? The actor knows or reasonably should know the other person is intoxicated by any substance such as the other person is incapable of consenting to the act. The law as it is now, I always equate it to like stumbling upon the drunk person and going, well, I didn't do it, because the way it's written, now is the actor has intentionally impaired the other person's power to appraise or control the other person's conduct by administering any substance without the other person's knowledge. So you have to be the one. You have to be the one to do that, to take the question of consent away. Think about the very notable case out of France, right? This is the husband and wife. I don't know if you've heard of this case, right? Husband and wife, where I think it's multiple rapes. Husband inviting hundreds of people over, and he's drugging the wife, and I mean, this is for a very long time. And some of the defendants in these cases said, well, we didn't know she didn't consent. Like, we were being invited over there, and the husband was saying this was okay. And so, I mean, you think about, I know this is a very, this is kind of what I'm trying to say is, this is a very, very, over-the-top example of what consent arguments could be about. But think about it from that perspective. That is something that anyone walking into that room should know, or through any reasonable person would know something's not right here. and they shouldn't be, the issue of consent should no longer be an issue in that particular case. And so while that's an extremely egregious case, I think it kind of crystallizes where the consent issue is the crux of many of these cases, particularly adult relationships that have formally have had consent. Those are the most complicated, right? Where you've had, I think one of the hardest cases I ever tried was former relationship, adult consenting relationship, former sexual relationship, and then that pivoted to breakup and rape, right? The jury is going to have a very complicated time with that. And so those are the cases where these types of measures can help shine a light on whether we think under the law consent is present or is not present. And it's not to say that these are de facto, right? You're going to have to enter in testimony about these things. Ultimately, the facts, I guess I put it this way, the facts of these cases aren't going to change in what's being presented. The lens which is on the jury's eye is going to change in the way that they interpret the facts that we either say consent can be present or not. So we're taking the lens and changing the lens by which they're going to view the same conduct. And I think that it starts from a point of these acts at their core need consent of both parties. And how do we reflect that in our law? I think Mr. Money's concern about this is very real. Because these are prosecutions that can be weaponized, and so you do need to be careful. And I'm sure we'll hear from witnesses that'll talk about, because we've heard from them before when we proposed this type of legislation, how this could possibly be abused. So we need to be certainly need to be conscious of those issues. But to your point, and I don't have the numbers in front of me, and you know them probably, but number of sexual assaults that occur that are never reported, those that are reported, and then go up to those that are finally prosecuted, those that people are convicted, right? It is limit at every stage. You have so many that are not even reported. So there is a problem baked into this system that this bill is trying to get to the core of. But we do need to be mindful of the guardrails on it. But I appreciate you bringing this and continue to further this conversation that we've been having for a bit now.
Thank you, Chairman. Thank you, Chairman.
Ms. Bowers has a question.
Thank you, Mr. Chairman, and thank you, Representative Johnson. I've got a few questions that deal with consent and intoxication cases. How do you envision prosecutors establishing intoxication levels respectively in court, particularly when BAC tests aren't administered in time? That's my first one.
I mean, just like when we try a DWI and we don't have a breath test, we look at the facts around the scenario to determine the level of intoxication, right? You've all been at a party where you can see somebody that's had a couple drinks and is starting to get buzzed, and somebody's got the lampshade on their head, is on the verge of passing out. And again, I think that's the question of the intoxication to a point that each of us probably have that monitor of which you would say, okay, you've gone too far, it's gotten too far. And that's at least what this does, is give, and we're not requiring a breath test or a sample or a blood sample of where your level of intoxication is. You might have it if you've got somebody that actually went in and did a SANE exam and has the toxicology for that. But otherwise, it's a fact-by-fact scenario where you are trusting that the prosecutors are making the right call on those facts, and then ultimately you are giving it to 12 people to equally use their own common sense and their judgment to say for each one of them, is this something that would have been at the line that you think meets this definition of intoxication to the extent that they're not able to give effective consent or withdraw it?
So then that leads me to, as you said, the provision regarding withdrawn consent. Can you explain how you see this being proven in court? I think you shared this a little bit in your explanation of what types of evidence might support these cases. I think you've answered that a little bit.
I think you're going to be really dependent upon the victim and the witness. And I mentioned what we see in many circumstances, fight or flight. There are some people that in a traumatic event, they're going to fight back. But there are some that freeze. And that's the challenge. If somebody starts beating up and clawing their eyes, we're going to go, oh, yeah, they didn't want it. But equally, when you look at the neurobiology of the brain in trauma, your brain is going to try to help you one of two ways. It's either going to say, fight like hell, and that's the way your brain responds, or your brain is going to freeze, and then your brain's going to try to help you forget. And so there's a lot of neurobiology on trauma, on how we do these investigations, and a lot that we have had to learn over the last decade, that not every victim looks the way you would expect.
Yeah.
And that's why, for that individual that freezes in that moment, again, we're turning it on that situation or that reasonable situation. Is this somebody that is a willing participant in this exercise, or did somebody go somewhere they knew they shouldn't have gone?
And I would add, you don't know in that moment how you would respond. You know,
You never
my
know.
instinct is telling me I'd fight like hell, but hell, I don't know what my response would be. So thank you for this. And the last part I think is because some constituents might be concerned about potential impacts on dating and relationships. So how would you respond to concerns that these changes might criminalize misunderstandings rather than malicious acts?
I think, again, you're trusting, just like we tell every juror when they come in and we say, look, you didn't check your common sense at the door. We've all been in dating relationships or know people that have been in dating relationships that can talk about however they want to talk about how they got connected with their folks or not. Again, I think when you look at the examples of what we're talking about on sexual assault, oftentimes perpetrators, every victim I know feels shame. Every victim I know thinks they did something to deserve it, whether it was smoking a joint as a kid or drinking too much, going to the party, wearing a skirt they shouldn't have worn. Every victim beats themselves up first because no woman wakes up every morning and thinks today's the day I'm raped. So we all feel a denial of they must have done something to put themselves in a position I wouldn't. And victims feel that too. There is so much underreporting. There is so much shame. Again, in this circumstance, we really are talking about not sexual promiscuity, not regret. We're talking about rape. Rape that is being hidden by the law right now, allowing the perpetrator to control the prosecution. And that's why we're asking for these changes based on what we're actually seeing in the courts.
Thank you so much, and thank you for bringing this
appreciate
piece
you.
of legislation
Thank
to
you.
us. Thank
Ms.
you.
Jones?
So when I was in college, I ran track, and I was a freshman. And I was in the track office, and one of the upperclassmen, my teammates, was there, and he was really popular, and I liked him, not liked him like I wanted to date him, like I liked him. I thought he was cool. I thought he was trustworthy. And it was just us in the track office. And he comes on to me. I ask him to stop. I didn't fight him. I mean, prior to this happening to me, I thought I would have fought, but I didn't. And all these things were going through my mind. And then he forced himself on me, and I just sort of laid there. I just sort of laid there. I didn't really know what to do. I didn't know how it happened. And then, and it happened. It was weird, uncomfortable. And I didn't say a word to anybody. My roommate, 2 years later, encountered this same guy, and he tried to do it to her. Except for he wanted to tell everybody she was promiscuous. She was not. But it was a way to stop people from believing her. And amazingly, I stood up for her. I said no, because he did it to me. So when people talk about how you respond when stuff like that happens, people look at me. I mean, I'm a big girl. I'm a strong girl. But people would say, well, Jolanda, you never would let somebody do that to you. I am telling you, under the right circumstances, anybody can be raped. And you just don't know how to protect yourself. And when people came to me afterwards, because they were trying to figure out why I was picking like the freshmen, so I guess there was a pattern that he chose freshmen. while I was standing up for a freshman over, by this time he graduated and was just training there. So it's hard, because some people will say, well, you should have said something. And so I actually, when I think about it, I like the bill because it protects people who are like me. That's all I want to say.
Thank you for sharing.
Okay, thank you. Mr.
Representative Johnson, thank you for bringing an effective tool for prosecution. Thank you.
Thank you, Chairman.
We'll call the witnesses.
Can we start with Summer Willis?
Chair calls Summer Willis, yes.
Good afternoon, Chairman Smithy, Vice Chair Wu, and members of the committee. My name is Summer Willis. I'm representing myself, and I am here to testify in support of House Bill 324. 10 years ago, as a sophomore at the University of Texas, I was raped. I became a victim, a title I never wanted to have. For nearly a decade, I carried this pain in silence, believing that if I buried it deep enough, it would go away, but it never did. So I tried to move forward. I joined Teach for America, Peace Corps. I married a fellow volunteer and have 2 beautiful boys. But the trauma stayed with me, and it was something that I couldn't outrun. So I did the only thing I could think of. I ran towards it. I gave myself new titles: survivor, advocate, endurance athlete. I turned 29 last year, and I ran 29 marathons across this country, meeting survivors in every city: mothers, runners, students, news anchors. I carried a mattress for an entire marathon to symbolize the burden that survivors carry. I crawled 13.1 miles last month in Austin, because that's what survivors do. We crawl through a system that's stacked against us. And after all that, after reclaiming my story, I learned something devastating. What happened to me, the rape that changed me, that haunted me and nearly broke me, wasn't even considered rape in Texas. Because I was drugged by one person and raped by another, the law didn't recognize my assaults. I come in here today with a weight on my shoulders, knowing I will never get justice for what happened to me. But I've heard if your dreams only include yourself, you're not dreaming big enough. So today I'm asking you to dream with me, because we have the ability to right this wrong together. We have the power to make sure that no survivor is betrayed twice, one by their rapist and one by the system that's supposed to support us. Let me be clear, Texas does not have a legal definition of consent, and without it, survivors are denied justice before we even have the chance to speak. 75% of college rapes involve alcohol, and students are 3 times more likely to be sexually assaulted in college than any other times in their lives. And yet, Texas law refused to protect us. Out of every 100 reported rapes, only 1 will result in conviction. 1. I've asked myself a question that no Texan should have to ask. Would it have been better if I was raped in a different state? Oklahoma, Florida, states with definitions of consent. Because at least then the horrors of what happened to me as a college student would be acknowledged. At least then I would have a chance at justice. So today I'm asking you to dream bigger with me of a Texas where survivors have a choice, because we can change this. We can define consent in Texas and give survivors a fighting chance. Thank you.
Thank you, Ms. Willis. Any questions, members? Thank you so much for being here today.
Thank you.
Chair calls Jana Oswald.
Good afternoon, Chairman Smithy, Vice Chair Wu, and committee members. My name is Jana Oswald, and I'm here representing Harris County District Attorney's Office, testifying in support of House Bill 324.
And yourself, right?
Yes, sir. I currently serve as the Division Chief of the Adult Sex Crimes Division of the Harris County District Attorney's Office, where I have been a prosecutor for more than 15 years. In my current role, I supervise the filing and the prosecution of all adult sex crimes cases in Harris County. Amongst the 8 prosecutors that I supervise in my division, we review over 900 adult sex or sexual assault investigations that are presented to us every year for charges, and are currently handling over 800 active sexual assault cases, almost 200 of which are set for trial. I not only supervise prosecutors who's handled these cases, but I've handled hundreds of sexual assault cases of children and adults and have tried dozens of these in my career. A very real fact pattern that was presented to my office just yesterday. A victim goes on a work trip with a colleague. For some reason, they are forced to get a room together where they fall asleep in separate beds. They go to sleep without incident, and the complainant wakes up to the defendant on top of her with his penis penetrating her vagina. The complainant describes being shocked, scared, afraid, and confused of what is happening. So she freezes. She freezes. She doesn't flee. She doesn't fight. She freezes. She says nothing, but she cries, and she survives. And when the defendant is finished, she doesn't say anything. She doesn't act the way that I hope that I would by fighting, or if I don't fight in the moment, by immediately getting up and indignantly walking out and reporting it to the police. No, she survives. And when she feels safe, she reports the sexual assault to the police. And while all of us in this room know in our hearts that this is a sexual assault, this is a case that already causes me and my prosecutors concern when considering taking charges. Because under our current statute, with its rigid and enumerated ways to show that this scenario is without consent, we cannot prove consent was not given. The complainant froze. She did not fight. She did not flee. She didn't affirmatively express her lack of consent, even though she never gave her consent. She is like one of many survivors who doesn't say no, but she also never said yes. And this case doesn't even involve the issue of intoxication. It just involves a suspect taking something he wants without any effective consent of the complainant. Sexual assault is a taking. It is a theft. It is the suspect taking something that was never given to them. This taking, this theft, steals much more than property of value. For children, it takes their innocence, and for all survivors, no matter of age, it takes their sense of self, their sense of dignity. As a member of this panel recently stated with regards to child sexual assault cases, it takes a part of their soul. Having had the honor of trying both adult and child sexual assault cases, I can definitively say adult survivors lose a piece of their soul due to sexual violence as well. Knowing that, in the way in which our law is written, my property, the credit card, the $50 sitting in my purse, has more protection under our laws than my own body. Under the law, I have to give effective consent for you all to take my physical property from me. But I have to prove my non-consent, or that there was the absence of it, to show that someone doesn't have the permission to put their penis in my vagina. As an adult, my property is protected more than a piece of myself. House Bill 324 would allow for us to clear a clear path to charge the case as presented because the complainant never gave effective consent as required under Section 107. But right now, I'm steeling myself for a very hard conversation that I'm likely going to have with this complainant because she didn't fight, she didn't flee, and she can't sufficiently articulate that the defendant used physical force, that her sexual assault means less under the law to our legislatures than someone taking the money from my purse.
Can you kind of wrap up?
Yes.
Okay.
House Bill 325 is utilizing tried and true standards, both in the consent as well as in the reasonable person standard that have been presented to juries all across this state. And they should be applied to sexual assault laws as well, giving the prosecutors the ability to bring these difficult cases that don't fit in a round peg square hole enumerated right now in 22.011, and allows us the ability to bring these tough cases before a jury.
Okay, thank you very much. Any questions, members? I appreciate you being here. Thank you. Anyone else here to testify for, against, or on House Bill 324? If not, Ms. Johnson, you want to wrap up?
I appreciate your time and ask for your favorable consideration on behalf of this bill. With that, I close.
Okay. Any other questions? Okay, Mr. Cook.
Rep. Johnson, with regard to the story that Ms. Willis told and said that neither one of the actors were, I guess, were they charged? Do you know?
No. In fact, she did not feel comfortable coming forward.
Oh, okay, okay.
And so I think that is part of the challenge, unfortunately, when we talk about underreporting.
Absolutely. But can we
Even
just,
if she had come forward, it would have been hard given the fact that one person intoxicated her, another person took advantage of that.
would a criminal conspiracy be an option, I guess?
I think it would be hard. Again, you'd have to try to show some law parties that they knew what the other person was doing and were participating in it. And so I think, again, in that circumstance, we're making prosecutors jump through a bunch of hoops to try to get around the defendant's ability to control. And that's what we know about perpetrators. They control the place, they control the time, and they control the person. This gives the prosecutors back the ability to give the victim the control back.
Okay. And you think that in this particular bill that you have before us, 324, is it mainly the consent issue that would have helped? And again, I'm not trying to personalize it too much with Ms. Willis, but I do appreciate her coming forward.
It's a
and
lack
her
of
story.
consent, right? And it's the reasonably should have known that based on that person's appearance that you shouldn't have gone there.
Okay. Thank you.
I appreciate it.
Mr. Wu?
Just real quickly, I know we mentioned this before, but I forgot about it. The issue of people pretending to be medical professionals and doctors is now coming back up into the news. There's been a rash of them, and it's a problem because you did consent to the medical contact, but that was assuming that that person was an actual doctor or nurse, right? And for us to charge them with practicing medicine without license, which is like a misdemeanor or something like that, or something which is not consistent with the actual offense, like somebody forcibly penetrated you without consent, right? Even if it was for a medical procedure, but that was only for if you were an actual doctor and not some random dude. So.
Thank you.
Okay.
Chairman?
Anything else, members? Okay.
I'm close. Thank you.
Thank you. And
Thank
we'll, if there's no objection, the chair will leave House Bill 324 pending. Ms. Hickland, you ready to go? Yes, sir. You just got one witness, so you've been sitting there a long time.
Oh, well, thank you.
The chair would lay out House Bill 1465 and recognize Representative Hickland.
Thank you, Chairman Smithy, committee members, for giving me the opportunity to lay out House Bill 1465. Imagine walking into and changing in a dressing room, using a public restroom, or even being in the comfort of your own home, completely unaware that someone is recording your most private moments. For too many Texans, this nightmare has become a reality. Invasive visual recording is classified as a sexual offense under the Penal Code. However, those convicted of this crime do not face the same consequences as other sexual offenders and do not have to register as a sex offender. I've read about countless cases relating to invasive visual recording that span from Belton to College Station and Amarillo to Highland Park. It's even this week in statewide news. The committee substitute for House Bill 1465 amends the Code of Criminal Procedure to require any individual who is convicted of invasive visual recording to register as a sex offender.
Hold on, let me stop you
Yes,
right
sir.
there. Ms. Jones, will you lay out the substitute? There's a substitute, I believe. So, Ms. Jones, will you lay out Ms. Jones lays out the substitute.
Okay, thank you.
Just procedurally, we just need to get the substitute before the committee, yeah. Okay. It's done. Okay, go ahead.
Okay, thank you. So the committee substitute.
Yes.
Additionally, this bill adds the definition of place in which a person has reasonable expectation of privacy to further clarify the locations in which an individual would believe they could disrobe in privacy without being concerned that they are being photographed or recorded, which includes a bathroom and changing room. Current statute already defines changing room as a room or portioned area provided for or primarily used for changing of clothing and includes dressing rooms, locker rooms, and swimwear changing areas. The committee substitute for House Bill 1465 centers around providing further protections for victims and aims to strengthen the definitions for invasive visual recording. Invasive visual recording is a crime of sexual nature, and this bill implements stricter consequences for offenders by requiring them to register as a sex offender. Before I close, I want to thank my witness, Kaylee Rush, for coming to share her story. You'll get to hear from her today, and her courage in coming forward underscores why 1465 is so important. Do I have two? Okay. Also, excuse me, I have two witnesses, also Lee Hartman,
Okay.
and both of them will share their stories that
right.
apply. Thank you.
Any questions for Ms. Hickman? Okay, thank you. Chair will call Kaylee Rush.
Thank you.
Okay, thanks.
My name is Kaylee Rush. I am representing myself today, and I am in favor for this bill. 2,322 days. That's how long I've been waiting for justice. November 12th, 2018, I found a voice recorder in my bedroom on the windowsill, with recording still in progress. Afraid of being on the next 48-hour mystery, my friend and I decided to plug the USB from the recorder into our laptop. The first thing we unveiled on the recorder was hundreds of child pornography images and videos. Some labeled stepdad and stepdaughter, some that were clearly children, prepubescent even. As sick as that made me, I couldn't believe what I found next. At the top of the list of folders, there was a folder labeled with the capital letter C. Immediately, I knew that had to be for my name. I took a deep breath, double-clicked the folder, and the first video that opened was a video through the air vent. Looking down through the cracks of the vent into my bathroom, there I saw younger me in the shower, completely vulnerable, unaware of the monster above me. To hear the investigators say how much effort it took to get the air duct off, and to see how long he took to find his perfect angle for the best shot of my adolescent body, and how hearing me sing my favorite songs in my sacred place is what drove him up the attic ladder, makes my skin crawl. There were 2 more videos that I starred in, one under my bedroom door while I got dressed after a shower, and one in his parents' pool of the pressure of the water from jumping in, moving my top around where I was exposed for a split second. As the thought that my stepdad, the city's head detective, the man I run to for protection, was the one behind this settled into my mind, a tsunami of tears flooded my eyes. I was heartbroken. That's the thing about betrayal. It's a silent thief. It takes away more than just trust. It steals your innocence. You lose your ability to believe in people without fear. It leaves you questioning everything that you thought you once knew. It's not the act that haunts you, but the thought that you never saw it coming, especially from the person you thought would never hurt you. After the discovery that my father figure was a predator, it took 5 days for him to get turned into the police. So once again, I was let down by the people who were supposed to protect me. Since then, I have severe anxiety, as you can imagine. I have trouble trusting anyone, but especially men. I can't even shower anywhere but my own home, where I still catch myself peeking around the curtain just to ease my mind that I'm all alone. This past Friday, March 21st, Brandon Matthews was sentenced to 8 years TDC, which was probated to 5 years for all 6 counts of the child pornography. And for the invasive visual recording, 18 months of state jail with credits and the opportunity for shock probation, which could result in a minimum of 75 days state jail, followed by the above 5 years of probation. My 2,322 days of waiting for justice to be served was all for me to be the one walking out of that courtroom feeling defeated and not the defendant. On top of the probation, Brandon has to register as a sex offender, not for the invasive visual recording, but for the child pornography charge. Without the additional charge, he wouldn't have to register at all for recording his daughter shower through the air vent without her knowledge. For a sexual act that traumatized a 16-year-old girl for the rest of her life, he doesn't even have to admit and be on the record as a sex offender. How do you fathom that? 2,322 days and counting.
Well, thank you for being here. Any questions, members? Yes, Ms. Bowers? Oh, I'm sorry.
Thank you, Mr. Chairman, and thank you, Kaylee, for, really, Mr. Chairman, it's not a question, it's just a comment, and you mentioned your understood anxiety, and I cannot see any of that right now. All I see is bravery and courage, conviction to come in here and share your story, and truly just proud of you.
Thank you.
Thank you. You're beautiful.
Thank you.
Thank you. Ms. Jones?
I just want to say we see you. We hear you. And hopefully, thanks to you, no other person will ever have to worry about this. So, and from one survivor to the next, it's hard sometimes to tell the story, but we need to hear the stories.
Thank you.
I've told several people that it takes a lot of courage to stand up, you know, and give a personal story like that. So we appreciate you coming.
Thank you.
Thank you very much for being here. Chair calls Lee Hartman.
For the committee, my name is Leah Hartman. I'm testifying on behalf of myself. Whenever you're ready.
Go ahead.
Okay.
And tell us how you stand on the bill.
I stand in 100% support. About a year ago, I was a victim of invasive visual recording. A camera disguised as a phone charger, one like this with the lens on the front, recorded me unknowingly in a bedroom. This camera had 33 videos, some of me in a state of undress. I was appalled to find out that an invasive visual recording was not a sex offense, despite the fact that it was clearly sexually motivated. Had it been a sex offense, maybe having to re-victimize myself for detectives, for lawyers, and for a judge would have felt more purposeful. I was even more appalled to find out how common the offense is. Invasive visual recording is rampant in Texas, with cameras being disguised as alarm clocks, outlets, and fire alarms. It is clear that the law often lags behind the rapid development of technology, but this legislation seeks to bridge that gap and bring justice into the present. I make two main points in my testimony to support House Bill 1465. First, it allows transparency for Texans. Texas does not have a single database where you can search all court records for the state. Each court is responsible for keeping their own records. Some courts add hurdles and require service fees. The sex offender registry differs. This is a statewide database run by the Texas Department of Public Safety with no charge for accessing records. Searching for a sex offender is generally easier and more centralized than searching for individuals with a felony conviction. And this is extremely important to community safety because a study in the Journal of Violence and Victims found that the community is more likely to protect themselves from victimization and engage in community reporting behavior when receiving notification from the sex offender registry. Also, the National Institute of Justice concluded that sex offender registration appears to have a positive impact on averting first-time sex crimes. But more importantly, this legislation protects children. In Texas, having a felony conviction is not an automatic disqualifier for employment in schools. In the Texas Education Code 22.085, schools are required to refuse to hire a person only if they are convicted or placed on deferred adjudication for a sex offense or a felony under Title V Penal Code that includes a victim 18 years or younger. Under this, perpetrators are still eligible for employment in Texas school districts if they have committed invasive visual recording, as long as their victim isn't under 18. Today's legislation fixes that gap. By classifying invasive visual recording as a sex offense, offenders will be barred from employment in schools regardless of the victim's age. And this is incredibly important to me because the person who committed the offense against me was employed in a classroom with young children, special needs children at the time, and continued his employment for 2 more months. Although I felt it would be obvious he could not be trusted with a vulnerable population, a representative from his school testified on his behalf in court that he was no danger to children, and she had no concerns about him being in a classroom with children. My story is one shared by many Texans. I urge you to stand in favor of privacy, safety, and the community and vote yes. As Representative Jones has shared, the home is the place where you should feel the most safe, and I no longer do. However, passing this legislation can prevent more Texans from feeling this way, or at the very least, deliver justice for those who become victims. I yield my time and am open to any questions.
Thank you so much. Any questions, members? Once again, we appreciate you taking the time to be here and share your story.
Thank you, I appreciate it.
Thank you very much. Anyone else here to testify for, against, or on House Bill 1465? If not, Ms. Higland, can you we'll recognize you to close.
Thank you so much. There's really not much more that I could offer beyond their powerful testimonies other than to emphasize that this is a sexual crime and therefore should be listed among required to be listed among sex offenders in the registry. Thank you so much. I close.
Okay, any other questions? Mr. Little has a question.
Thank you, Chairman Smithy. So Representative Hicklin, I spent a good bit of time with your bill, and obviously we already have a penal code provision for invasive visual recording, and from my understanding of your bill, your bill seems to seek to expand the number of places to which that offense applies. Is that right?
And it clarifies more that, so any place, we tried to clarify that area so that any place that there was a reasonable expectation of privacy, that would include a dressing room. So just to clarify that part.
And so one of the things I was struck by, and it's like it clicked when Kaylee testified, which thank you for doing that, is that the current state of 2115 appears to relate to the recording or broadcasting of persons in a changing room. And so when I look at, or a bathroom or a changing room, so it's kind of narrow, and when she testified, I'm like, this doesn't necessarily relate to a bedroom,
right,
where she was recorded. And so, I mean, immediately it clicked when she testified to that, but I have a question about the way that it's drafted in your bill. So your bill creates a new definition at 3A. It says place in which a person has a reasonable expectation of privacy, which I think most of that is well drafted. The problem I have is with the last sentence in it. It says the term includes a bathroom and changing room. So in the law, when we specifically include items, generally it's to the exclusion of all other items. So I think it might be well served to put the term includes, but is not limited to a bathroom and a changing room.
Sure, yeah, I'd be willing to.
The other question I have for you is, or the implication that I was dealing with as I was reading through your bill is, this seems to also be an offense that minor children can very easily violate. So to give you an example, my son at his public school, they have a rule, you're not allowed to have your phone in the bathroom or the locker room. But kids break that rule a lot. And so I'm just curious, have you considered the ramifications on the registration aspect of this if a minor child or a juvenile records someone else in a locker room or a bathroom, they're goofing off, if they end up registering, and for what period of time they register as a sex offender?
Well,
Can I help you with that?
yes.
The registration rules for juveniles are different than for adults. Most of the juvenile cases I handled, the registration is up to the judge, and we usually make pretty strong arguments that this is not a thing that a 14-year-old needs on their record forever, right?
That's helpful,
Yeah.
certainly. I wanted to know that for my understanding.
It's,
Yeah.
in fact, juveniles are actually probably the most likely to pick up these type of charges, and especially like distributing child pornography. They'll take pictures of each other and send them all around. They're going to get popped with that. But the nice thing is, at least in my practice, courts, prosecutors have been very understanding, and their main objective, especially with juveniles, as the state code says, is their main purpose is rehabilitation.
Right. Thank you, Vice Chair Wu, and I agree with you. It seems like this is something that juveniles probably violate with regularity, but I do commend Representative Hicklin's registration component of her bill, because normally when someone records someone like Kaylee, they're recording 10 different people, and this is someone who is an habitual offender, and I don't know what the word I'm looking for is, but it's compulsive, and they need to register so that other people can be aware of that behavior. So thank you.
Ms. Bowers?
Thank you so much, Mr. Chairman, and thank you, Ms. Hicklin. So I have a couple questions. One, do you envision this legislation leading to broader privacy protection reforms in related areas? And if so, what might that look like? And there's an additional question to that. So I'm going to let you answer that first, because I think it may lend itself somewhere else.
You know, this was just specifying making that connection between this is a sex offense and should be classified and prosecuted with the same punishments of other sex offenders. It's a matter of public safety. So sure, anytime that there's that, I would expect that there would be greater protection for privacy.
Sure. And thank you for that response, because, you know, it kind of leads me to the thought of short-term rental owners that we know are doing this in Airbnbs or any of those type places. It's happening. So could you see that maybe as a later reform, I guess, or adding that part to it, that it would pertain to short-term rental owners as well?
Yeah, I would refer to the discussion that I had with Representative Little, where anywhere that there's a reasonable expectation of privacy, and certainly that applies.
And that's what made me think about it, so thank you for bringing that up.
It's good.
Thank you.
Anything else, members? Yes, Mr. Money.
Thank you for your stories, ladies, and it's horrific. And I mean, I can't imagine that stuff like that happens, and those people should be on a sex offender list. I completely agree. I'm a little concerned, and maybe Chairman Wu would be the right person to answer this, or maybe it's you, but elsewhere in this invasive visual recording statute, B, it just says, without the other person's consent and with intent to invade the privacy of the other person, photographs or videotape, records, broadcasts, or transmits a visual image of an intimate area of another person, which could mean, a boyfriend has a picture of his girlfriend with her top off, and he sends it to his friend to look at. Shouldn't happen, never should happen. But that becomes a sex offense registration event, and that seems to be a different level or scale of offense than setting up a camera to record someone privately that they don't know. Do you see what I'm saying?
I think it's a different offense. So I think that's 2116, which is unlawful disclosure that doesn't require registration.
So 2115B though, and maybe I'm just reading it wrong, B1, photographs or by videotape or other electronic means, records, broadcasts, or transmits. And it's the or transmits part that concerns me. I mean, recording somebody without their knowledge, broadcasting it, sending it out to public view. I mean, all of it should be an offense. I'm not saying any of this is right or good or anything like that. But the situation, this statute seems to me, and once again, I'm not a criminal lawyer, but it seems to me to encompass more than just the egregious acts that we are covering here, that we've discussed. And I just want to make sure there's not an unintended consequence of making this extremely broad, which would which could lead to a situation where it's watered down and you don't really even know what that person did if they're on the sex offender list. If they have set up a camera in their Airbnb or in their stepdaughter's bedroom, I think the world needs to know that. But I wouldn't want that to just get lumped in with the other scenarios that I mentioned. Does anybody have thoughts on that? And
I don't know.
do we have a
We don't have
resource
any
witness
listed,
or?
do
Okay.
If you want to,
Well,
I can.
we
call.
can talk offline about it. Huh? It's good to have a resource witness, or, no, I agree.
Okay.
Sure.
Okay.
That's
Let me
yep.
interrupt your,
Yes,
your closing
absolutely.
for 1 second.
Yep.
And yes, Ms. Jones.
I don't know if I have the same concern, but I was thinking, I literally sent something to somebody accidentally. Like I was on my phone real fast. Nothing sexual. This is, let me get that clear, okay? I just want to get that clear. But I was on my phone real fast. The first name was the same. I literally thought that I pushed the one word, the one name, not the other. And I said, congratulations on your wedding. Hate I missed it. I'm in the state working hard for the people. And thought I sent it. And then I get a text back saying, huh? And so I looked and it was like, ooh, wrong Angela. So anyway, so sometimes you accidentally send stuff. And then I ended up going to the right Angela and congratulating on her marriage. And of course she was thankful for it. But I could just, I mean, I don't know where that falls, but you can accidentally send something. It actually came from you. So I'm just throwing that out there for the universe.
Okay. Let's call Jennifer Tharp. I hate to draft you into action, but if you're available, come on up.
Jennifer Tharp, Comal County Criminal District Attorney, and I did register in support of this legislation, originally not to testify. I'm happy to testify, though, because 2115, we actually amended it back in 2015. I was a part of a group of prosecutors. It was in response to upskirting. So this 2115 was originally adopted in 03. 07 is when transmit was added to the descriptor. And then in 2015, we didn't change transmit because it was yet just another means by which that recording could be accomplished. The question about students, I think that's covered in sexting, which is a different statute, 43, I think it's 43261. But I'm happy to answer any other questions if that didn't address it.
Mr. Cook.
But what about the question that Mr. Money was asking? I mean, what if a prosecutor, tried to prosecute under this? Would it be mandatory report? I mean, if this bill was
So
passed?
2115, as what's being proposed, would require registration. And I will tell you, I've prosecuted a lot of invasive visual recording cases, very similar to the testimony that was received today. In terms of what you talked about, let's say it's an image that a boyfriend has and then shares it with another individual. There's 2116, which is, when the statute was passed, it was passed as revenge porn. So let's say an image is shared willingly of an intimate area with a boyfriend, and then they are basically manipulated by virtue of that image. When that was passed, I don't remember which session, a couple sessions back, there was a lot of testimony where it was used to extort them. So it was called sextortion back then. So does that?
Yeah, yes, and so there may be better statutes for those kind of scenarios. I'm just concerned if it could be brought under this statute. And I'm not saying that they're,
Sure.
all prosecutors are not as intelligent and have as much integrity as you do or whatever. But I think that there's if you have a statute here that says that merely transmitting a visual image of an intimate area, or even the next one, B2, photographs by videotape or other electronic means, broadcasts or transmits a visual image of another in a bathroom or changing room. That doesn't even have to be that does not even have to be an intimate photo, according to the
Correct.
terms of it.
Yeah, so I've prosecuted cases directly on point on this.
Yeah.
One particular case, it was bathrooms that were set up in both, or there were cameras set up in both bathrooms. One, that the gentleman captured images of his stepdaughter, and then he also filmed his wife in the bathroom, in the shower, using the toilet, bathing herself.
Yeah, that's horrible.
Yes,
Wretched.
it was prosecuted under this section. Now, let's say it's a situation B2. That's some of the old language because there is that public policy aspect that if I go into a changing room at fill-in-the-blank clothing store right now, and I take my clothes off to try on a dress, I have that expectation of privacy. That's B2. And to prosecute someone changing, if a camera is hidden in that changing room, to prosecute, it doesn't just have to be an intimate area. So if I am changing and the camera, the way that camera is positioned, doesn't necessarily record an intimate area of my body, that doesn't mean it still cannot be prosecuted under B2. Because there's that expectation that in that changing room or a bathroom, you should be private.
Absolutely. Let me take it out of the kind of voyeuristic nature of things. Let's say that I take a picture of myself in the bathroom with my shirt off, and I want to show that I've got something that I'm concerned about that's on my chest. I don't know, a boil or something, and I send it to my friend Representative Verdell over here, and he looks at it and he thinks, oh, this is embarrassing, and with intent to invade my privacy, he sends it to Mitch Little and says, look at this.
Don't bring me into this.
Look at this photo that I have. Does that not violate this because he did it to invade my privacy? It's a photo of me in the bathroom, and he's transmitted it to somebody else. And that's, that's a, I'm not saying a prosecutor would go after it.
In this interesting hypothetical of the three of
Yes.
you, it's not an intimate area because you're just taking a picture of your chest.
Right, but it doesn't say intimate area
No,
in
B1.
B2. B2, it's an or.
Okay, so in your dressing room scenario, could that possibly, sure. It sounds like from your hypothetical that possibly could do that.
Now, I don't know that a prosecutor is going to go after us for that.
Well,
that's not probably interesting to a prosecutor.
You kind of have to go back to just the first part of B. And B says a person commits an offense, so the person, without the other person's consent and with intent to invade the privacy of that other person. I would have to establish that Representative Verdell was trying to invade your privacy without your consent by sharing it to Representative Little. And all the facts that you've given me to this point, it's weak at best. So could it hypothetically potentially be indicted? Sure. There's a lot of fact scenarios that get presented to prosecutors all the time. At the end of the day, as described earlier, I have to prove each and every element beyond a reasonable doubt and then convince 12 citizens of that.
Even if I just said, hey, this is kind of embarrassing, please don't share this with anybody, and I sent it to him, and then he's like, I think it's funny, and he sends it to somebody else. Now he's branded as a sex offender for the rest of his life, and there's nothing even sexual about it.
If I could get 12 citizens to
Right,
bite
yeah,
off on
I
that.
got you.
And I don't know
Okay.
that I could
All right.
because I'd have to establish that in this whole process, Representative Verdell was trying to invade your privacy.
Okay.
Chairman Smithy, may I?
Yes, Mr. Little.
Thank you, Mr. Chairman. Thank you, DA Tharp. Now, I'm glad that you're here. You said something that the light bulb kind of went on, that there was modifications to 2115 for upskirting, and I went, where is that in the statute? And I finally understood. So that's what I would call a B1 offense.
Correct.
So under B1, you're transmitting a visual image of an intimate area of another person if the other person has a reasonable expectation that the intimate area is not subject to public view. So that could be on the subway. It's not specific to a bathroom or a changing room. Am I right?
Yes, sir.
Okay. B2, which is really the definition that's being tweaked, primarily, is transmitting from a bathroom or a changing room, regardless of whether it touches an intimate area, right?
Correct.
Okay, so
Because there's a greater cloak of privacy that those rooms are afforded.
okay, so if you record someone in a bathroom or a changing room and you don't see their private parts, you don't see their underwear, it doesn't matter because that is a B2 offense, period.
I still have to show that their intent was to invade the privacy of that other person.
Well,
But-
yeah, you're there. If it's somebody's recording in a bathroom or changing room that's not theirs. So it's not, walk me through it.
I pause on that because you could have a group of, let's say, 20-year-old women in a bathroom and someone's got a cell phone out and they're recording and they're laughing, they're washing hands, or they're fixing their makeup. That's a recording in a bathroom, but I wouldn't be able to prove, I think, that it was with the intention to invade the person who has filmed privacy, even though
I
it's in
see
the
your
bathroom.
point. I see your point. I'm thinking more along the lines of passive recording. But the problem is that if we take Kaylee's situation in its most literal form, someone could record her in her bedroom, and as long as they don't capture her intimate areas, they haven't broken the law.
Correct. In the case
Light
that I
bulb.
prosecuted, we had recordings in the bedroom, and then we had recordings in the bathroom. I alleged every recording in the bathroom date. I didn't do the bedrooms because the bedroom wasn't within this statute.
Light bulb. I get it. But I have to nerd out with you for a second on one thing. So my point was, if you look at the do you have the bill?
No.
I'm sorry.
It's
All right.
okay.
So my concern is that in the definition that is prescribed by the bill, place in which a person has a reasonable expectation of privacy, the last sentence says the term includes a bathroom and a changing room. And my concern is,
Including but not limited to is better.
you agree? Okay. Good. So I'm not crazy.
Including but not limited to is better language.
All right. Thank you, D.A. Tharp.
Wait, hold on just a second. Ms. Jones had a question. Sorry about
Remember,
that.
I didn't register to
resource
testify.
witness
right?
you.
You're not going to get away that quick.
Resource witness you. So, I heard some of your explanations, and there's a joke in the criminal law area that says you can indict a ham sandwich.
Correct. As a prosecutor, if you do it, you're stuck eating it, though.
Right. Okay, but that really doesn't matter because you're indicted, right? Which triggers a whole bunch of stuff. Because in the grand jury, the only person there presenting testimony is the prosecutor most times, and the defense lawyer can't be there to challenge anything. At best, all we can do is give a grand jury packet. I mean, I know that's what they call it in Harris County. I don't know what they call it in Comal County, if it's the same thing. And then you're not there to argue your point. So I think that that's saying it might not get indicted, and it's been my experience in the 30 long years I've been doing this.
I only have 20 on you.
Okay, so that there are some prosecutors who indict like meritorious crimes. There are some prosecutors who want to throw everything on the wall and see if anything sticks, and then use everything on the wall to scare someone into signing, and they keep things, and once something is indicted, you can't unring that bell. So I just have some concerns about that. I mean, I know it's not your bill. I know you're just a resource witness, and I know you didn't even know you were going to be a resource witness before you
wasn't
got
planning
there.
on it.
So I'd just like for laws to be written that strictly target what it's intended to resolve because of unintended consequences.
Mm-hmm.
So
I think you raise a great point, and it also raises the issue on why each and every one of you should vote favorably for this bill, because I will tell you, back in 2015, we worked in the interim, and we worked, I can't tell you how many hours I spent trying to fix this statute. And in that, we talked about recordings devices. I never realized the oversight we had with a bedroom, and I should have known that because I had seen cases as a prosecutor where the recording took place in a bedroom. Thankfully, in those particular cases, there was an intimate area that was recorded. But, I mean, you raise an excellent point. It's important, each and every piece that comes before this committee and every committee, to be as narrowly focused as you can be. I understand the questions, and I'm just trying to answer them.
So, no. I mean, I know it's not your bill, but I know you have 20 years of experience. Mm-hmm. But I actually don't think that makes what I said makes your point. I think it makes my point that it can be used in something like to catch people into something who weren't intended to be into that something. And I also know, there are some nefarious prosecutors, and there are some good ones, some nefarious prosecutors who do stuff, but there's also prosecutors who couldn't evaluate a case to save their life. like where I've been like, dude, you really don't need to indict this. Dude, we really don't need to go to trial and get a 5-minute not guilty, which, by the way, is my world record. So that's how bad her case was. But she was stuck on my client and wanted to get him for something. So I just have to figure out
Sure.
myself. I'll speak with the bill's author.
Right,
to
wrong,
see-
or indifferent.
Right.
There are bad actors in every profession.
Okay, well, thank you.
Mr. Riddell?
Thank you, Chairman. I have one question. So last session, there was a male in the female bathroom here. The person took a picture of that male in that bathroom. Based on what I see here on B2, does that mean that that person, for taking that picture of the male in the bathroom washing his hands, would now be listed as a sex offender if they did that again in this past?
So I don't want to be, as a resource witness, utilized.
No problem. Just under the law, I'm just asking if that person would
So,
fit that criteria for being a sex offender.
2115 defines several aspects: changing room, female breast, what intimate area is included, and then what areas are included as well.
Okay, and B2 doesn't cover anything other than just saying that the person takes the picture in the bathroom. Is that correct?
B2 said, I don't have the bill in front of me.
Oh,
I'm
that's
looking
right.
at the
Sorry
actual
about that.
statute, sorry.
Okay. Okay, I'll save the question for
Okay.
Representative Hicklin. Thank you.
No problem.
Okay.
Oh, just kidding.
Just to be clear.
Mr. Wu?
Yes, sir.
Just to be clear, the inadvertent and non-invasive videography in a place like a bathroom. So like, let's say people will shoot their TikToks in a bathroom, which I don't know why you would do that, but people apparently do that. And people who walk by in the back of the frame, they're in the picture, right? And they're on the video, and a lot of people don't want to be in those videos because why are you shooting a TikTok in the bathroom? But that's not the point. So, but the current law would not catch that as a criminal. That would say like, that does not meet the definition of what we're trying to do, correct?
I'm not sure I understand your hypothetical, because you still have to go back to the first part of B has to be established, right? With the invasion of that person's privacy.
Right, you have that, the intent of the person taking the TikTok and doing a little dance was not to invade the privacy of the person who's walking in the background.
Correct.
And that's very clear from the situation.
Correct.
Ms. Tharp, thank you so much. You've been a good sport to come up. We appreciate your input on this. And Ms. Hicklin will, the chair will recognize you again to close.
Not the first time. Okay, yeah, I'm actually grateful for a little extra time to clarify, because I think there's some confusion right now. The focus seems to be on the definition of invasive visual recording, and we're not touching that. That's already established. What we're talking about is just including it as an offense required by the sex offender registry. Representative Little, you talked about, you focused on B2, but this is actually, it doesn't touch that area. This is actually in Section 3A, where it specifies that private area of a bathroom or a changing room, which Representative Vice Chair Wu, I believe that's one of the things that you were talking about. So I'd like to emphasize the term explicitly only applies to the private area of a bathroom or changing room. If an individual takes a photograph or visually records someone in the public area of the bathroom or changing room, such as the common area where one washes their hands, the eligibility of sex offender registration does not apply. If an individual takes a photograph or visually records another individual who has reasonable expectation of privacy, such as an individual in a private stall or personal changing room, the applicability of sex offender registration would apply. So there's that distinction between the private area. I think that some of our conversation has touched on some important details, but miss the fact that this is established it's already established. It's a sexual crime. These are sexual offenders, and as such should be included on that sex offender registry in a way that would contribite to public safety.
And I'm not sure anybody really disagrees with that, in the right.
That's the only thing that this bill does. It doesn't, and any change. No, it does not create a new crime. It only makes this as one that requires registry. Thank you.
Okay, any other questions? appreciate you.
Thank
being
you.
here. And so if there's no objection, the chair will withdraw the substitute to House Bill 1465 and leave House Bill 1465 pending for now.
Thank you.
Thank you very much.
Thank you.
You ready to go? Okay. The chair recognizes Ms. Hernandez. And the chair lays out House Bill 1445 and recognizes Representative Hernandez.
Thank you, Mr. Chairman and members. House Bill 1445 would allow a county's managed assigned council executive director to appoint a designee to approve payments for attorneys appointed for indigent defense. In 2011, Texas established the Managed Assigned Counsel Program, or MAC, to provide quality representation to indigent defendants who may not otherwise be able to afford it. However, current state law only allows the judge or Managed Assigned Counsel Director to approve these respective attorney payments. This is manageable and cost-effective in smaller counties, but logistical issues arise in larger counties. For example, in Harris County, the MAC office assigns over 200 attorneys to indigent defense across 16 criminal county courts, resulting in the MAC director having to approve roughly 700 attorney payments on average every single week. The size and volume of payment approvals in Harris County have created a substantial administrative burden for the MAC director alone. Additionally, the current Harris County MAC director is a member of the National Guard, whereas if you went on military leave or in some other way became unavailable, attorney payments could be unreasonably delayed. This bill would allow the county's MAC director to appoint a designee that would assist in approving payments to attorneys participating in the MAC program. This would significantly ease the administrative burden on the MAC director, allowing for the program to operate with greater efficiency. This change will help to ensure that indigent defendants receive the quality representation that all Americans deserve, while also ensuring that participating attorneys receive their due compensation in timely fashion. I believe we have a witness here from Harris County, and we'd be happy to answer any questions and reserve the right to close.
Thank you, members. Do you have any questions for Rep. Hernandez? Seeing none, we'll call Kenneth Harden. Hi, Mr. Harden. Would you please, you're Kenneth Harden. You're representing the Harris County Commissioners Court, and you
Yes,
are
sir.
for HB 1445, correct?
That's correct.
Thank you. Please proceed.
Yes, good afternoon, established members of the committee. My name is Kenneth Harden, and I have the privilege of serving Harris County as its Executive Director of the Office of Managed Assigned Counsel, and just for brevity, I'll call it the MAC office. This is a critical operational challenge affecting timely compensation of court-appointed attorneys. Like other counties with a MAC office, our office exists to ensure that individuals accused of a crime who cannot afford counsel receive qualified counsel, and to maintain fairness and independence, the MAC operates independently from the judiciary. So actually, the term court-appointed is no longer really used under our office. So that being said, we oversee attorney appointment support and, more importantly, voucher or invoice processing for attorney payments, which is why we're here and what Bill 1445 speaks to. In Harris County, as you all know, the third largest county per capita in the nation, our office processes an average of 744 vouchers across 16 courts, a volume that continues to grow every year. Despite our office's commitment to efficiency, the current law only allows two parties, the MAC director, myself, or a judge, to approve these payments. As it stands, that is the issue. That requirement creates a failure in the system that serves, for example, our office nearly 85% of all appointments across those 16 courts, indigent appointments across those 16 courts. So just to give you more numbers, in the fiscal year 2024, we processed 36,618 vouchers, and that represents 8,000 more than the previous fiscal year in 2023. So if it's not addressed, we risk serious disruptions to the financial stability of more than 200 attorneys who depend on timely payments to sustain their practices and continue serving our community. And just as a point of clarification, I do not work, I'm not a member of the National Guard, but I do want to give an example of what we mean as far as this bottleneck and what it causes. Our team works tirelessly, right, including nights and weekends and personnel, to prevent these delays. And this is unsustainable. To ensure that attorneys, for example, were not financially impacted, I personally reviewed and approved every single voucher during every single day of my honeymoon. Thank goodness that my wife was very understanding, and it was something I was proud to do. Don't tell her that. But nonetheless, it just kind of gives you an idea. So if I were a member of the National Guard, for example, and I did have to be deployed, right, that would create an issue. So this is not a sustainable model. The ability to delegate approval authority means that, for example, any other foreseen circumstances, if I fall ill, if there's a family emergency, that could grind payments to a halt. And that can create unnecessary delays that otherwise wouldn't exist. So House Bill 1445 is, plain simple, a common sense, no-cost solution. It just would allow MAC director to designate qualified staff to assist with voucher approvals, ensuring that attorneys are compensated without necessary delays, and it costs nothing to taxpayers. The issue is not unique to Harris County. I was said before in opening statements that both urban and rural MAC programs across Texas face staffing and resource challenges. Larger counties experience overwhelming caseloads, while smaller counties, right, they have to struggle with limited personnel who has to multitask across multiple responsibilities. So by granting MAC programs the flexibility in managing voucher approvals, this bill ensures effective use of time and resources statewide. So, in closing, by passing House Bill 1445, the legislature will not only support efficient county operations, but would also protect the financial stability of the attorneys who ensure equal access to justice for our most vulnerable citizens. I respectfully urge your support of this bill. I appreciate your time and consideration, and I'm happy to answer any other questions that any of you may have.
Rep. Jones first.
As a victim of this system, I literally have stopped. So I didn't know that the MAC, that you, for some reason I thought it was just the judges that signed off. So I've called judges and be like, hey, man, you gonna sign this voucher?
Yeah.
And have had to wait for over a month to be paid. And then it's like, okay, well, I don't want to work in that court anymore. And then they don't have lawyers who want to take cases for indigent defendants.
Yeah.
Because if you're not paying me for work that I actually did, I literally would not be able to sustain my practice. So really, I could have gone to MAC. I didn't know that. But so I definitely know that with me personally, I've stopped doing work in certain courts because it took super long to get paid.
Yeah.
And most people are used to getting paid every 2 weeks. You shouldn't have to wait for over a month to get paid for work you actually did. So thank you.
Thank you. That is an ongoing challenge that we hear quite often.
Rep. Moody.
I guess just to put a point on Representative Jones's concerns as a practitioner. Obviously, folks have constitutional right to counsel if they can't afford one. So when we set up a MAC or permit a MAC to appoint counsel, those attorneys are voluntarily stepping into that system, right? You're not conscripting them to service. They have to say affirmatively, and then that usually have to submit. They have certain requisite experience to receive appointments on misdemeanor, state jail, felony, capital murder, all that other stuff.
Yes.
And in your jurisdiction, you have set fees in court, out of court?
Yes,
Like those
we
are
do.
set.
We
So,
do.
I mean,
We also
so-
have qualifications as well for them to
So-
be on the list.
So what I want to I just want to put this point on it. There are guardrails around how these payments get made, and they are woefully lower than what an attorney is going to make with a client who is able to afford their own counsel. So you have lawyers volunteering to do this that have qualifications that have been vetted, and the slower, and I guess not really a question, but the slower you do this, not you, but the slower the system does this, the less incentive you're going to have for attorneys to join in these. And I think probably the more likely that we're going to have constitutional violations of people's rights, because you just have fewer and fewer attorneys that are doing this work, and the cases are still there. They're going to move slower. We're not doing our part to process these things. There's already guardrails in place in terms of cost. And so to me, this seems like a no-brainer. This is just trying to make things more efficient we have guardrails all over the place in terms of making sure that we have the right attorneys in the right places doing this stuff. So I appreciate your testimony and letting us kind of drill down into something that's a little bit different than what we've heard today. But I mean, we're talking about constitutional rights here, so I think it's important the way that we actually get this system working efficiently.
Thank you. Thank you. I appreciate that. Thank you.
Any other questions? Ms. Jones?
Speaking to Chair Moody's point, perfect example of how we volunteer to do something that other people wouldn't do. But the reason I take some court-appointed cases because I also have free will cases, which are that's hood slang for retained cases. But my uncles told me that they got locked up because they had sellout court-appointed lawyers, so I don't think you should get locked up because you are indigent. So I do some court-appointed cases. I can remember a case where I had a motion to suppress. There were two lawyers. I was the court-appointed one, and another lawyer was a retained one, and we both got the case thrown out after a suppression hearing, and he made $25K, and I made $1,800. And so I promise you, this is God's work. It's God's work. And if we're making that little compared to what you could get in the free market, and we're getting paid slow, that again, there are certain courts where, and let me also say this, as a person who's been a court-appointed lawyer, and I fight hard for my clients, it doesn't matter whether they paid me or I'm court-appointed. I've gotten court-appointed murder cases thrown out, right? Because some people think if you're a court-appointed lawyer, you're a sellout. We're not. I got, I think, 2 or 3 cases thrown out last week as a court-appointed lawyer. We do this. It's hard work. We're generally not appreciated.
Yeah.
And to add insult to injury, we're getting paid slow. It definitely is slowing down the administration of justice. I absolutely believe that it is violating some people's constitutional rights. And at a minimum, if you're charged with something, you should be entitled to a lawyer because the Constitution requires it. So thank you.
Oh, thank you. I'm proud to serve and work along with other attorneys who feel that way. I've dedicated my life's career to injured defense, and I've never been anything other than that. And so I appreciate those comments, and thank you. I believe this bill could be a major step forward.
Okay, any other questions, members? Okay, thank you very much, Mr. Hart. Anyone else?
Thank you.
Thank you for being here. We appreciate it. Anyone else here to
Thank you for having me.
testify for, against, or on House Bill 1445? If not, the chair recognizes Ms. Hernandez to close.
Thank you, Mr. Chairman and members, for your time today. And if there are no other questions, I close.
Okay. Thank you very much. If not, the chair will leave 1445 pending for now, and appreciate you being here. Okay. The chair lays out House Bill 502 by Representative Flores and recognizes Representative Moody to explain the bill.
Thank you, Mr. Chairman, Vice Chair Wu, members. I'm laying this out on behalf of Representative Flores. She has a personal matter that she had to tend to today. Otherwise, I know she would have wanted to be here laying this out. I'll give you the very short version. We allow certain victims of certain offenses to have confidentiality of their identifying information. So the use of pseudonyms, depending on the type of offense. So victims of trafficking, sexual assault, family violence, we have certain offenses where we permit pseudonyms to be used. What this bill does is it opens that up to two other categories of offenses. One of those is indecent assault, and one of those is invasive visual recording. And so this is victim-centric, so if the victim wants to, these are also congruous crimes to those that we've already covered with pseudonyms. And so victim wants to do this, wants to have that privacy, it becomes an option for them under this bill. I do just want to let you know the history of this, and so that way y'all can kind of see the posture of where it's at. This session, the Senate companion to this bill has already been voted out of committee, and it's on the local and uncontested calendar for this week. So this is also a bill that made it very close to the governor's desk, passing both the House and the Senate, but wasn't finally sent to the governor last session. So I don't think there has been objection to this as it's gone through the process. I will do my best to answer any questions if you have them about this bill, knowing that this is not my bill, but I do understand the policy underlying it, and I also understand that there's broad support for this, and with the Senate bill probably on its way very shortly, I think we can finally get this into law for these victims.
Okay, any questions for Mr. Moody as the fill-in author of the bill? Okay, thank you, Mr. Moody.
Thank you.
We've got one witness who the chair will call Stephanie Garakian. I'm sorry if I mispronounced your name.
Good afternoon, Stephanie Garakanian. I'm here on behalf of the Travis County District Attorney's Office in favor of the bill. I know that you all have had a long day, so I'm really just happy to answer any additional questions that you might have. I think the rep did a great job putting it out.
Okay. Any questions, members? We appreciate you being here.
Wonderful. Thank you so much.
Anyone else here to testify for, against, or on House Bill 502? If not, Mr. Moody, if you want to close.
Yeah, I do, and I think it's important to note, I mean, that these are real people with real cases, that's the reason why Representative Flotis has this bill, and I think it's the reason why the Travis County District Attorney's Office was here. Just to put a finer point on this, there was a case in where a woman learned where she was being recorded while breastfeeding at her place of employment, and she was left in a very difficult position of pursuing charges, but also her information being known in her place of employment. And so those are the types of real-world situations, the difficult places that these victims find themselves in. And so I know that's why it's a focus of Representative Flotis' office. And so I appreciate your consideration. And if there are no questions, I would close.
Okay. If no other questions, Ms. Jones? Okay. Okay. So with that, the chair will leave House Bill 502 pending. Ms. Gomez, you want to come up? The chair lays out House Bill 1121 and recognizes Mrs. Gomez. We apologize for you.
Not at all. Thank you so much, Chairman. I'm so appreciative to the chair and our esteemed members here today for allowing me to introduce HB 1121. HB 1121, members, addresses an issue that has been quite a hot topic in the media lately, not just in the state of Texas, but across the nation, addressing the harassment of individuals through the use of quote-unquote deep fakes or artificially intelligently generated images. In a nutshell, this bill simply adds the AI-generated images language, the computer-generated images language, to our existing revenge porn statutes, which address real images. It's basically bringing our Section 21.16 of the Penal Code and Section 98B of the Civil Practice and Remedies Code up to date in our 21st century computer-generated problems that we're having. So HB 1121 would work within the framework created by law by adding deepfakes and AI-generated images to our revenge porn laws. I intend to promote the highest level of protection from individuals from harassment by these AI-created images, and HB 1121 would help to promote that vision. And again, would add this AI-generated language into the existing deepfake statute, which make any dissemination of this intimate visual material a state jail felony, and by adding this AI-generated images language to our civil liability statute in the Civil Practice and Remedies Code. So just, again, bringing this up to date with the remedies at law they're already entitled to civilly, such as actual damages and attorney's fees.
Any questions, members? Okay, thanks. I'll go ahead and call it. We've got one witness.
Thank you, Chairman. I'd reserve my right to close.
It will, certainly.
Thank you.
The chair calls Adrian Shelley.
Thank you, Mr. Chairman. Members, Adrian Shelley with Public Citizen, speaking in support of House Bill 1121. Representative Gomez, appreciate you filing the bill. Passing out some written testimony that is admittedly a little bit duplicative with what I passed out earlier. So I'll just say very briefly, there are three statutes that we're amending here. There's the civil tort of disclosure of promotion of intimate visual material. We are adding joint and several liability for individuals whose applications or software is used to create this material, and we are adding into the penal code to the crime of unlawful disclosure or promotion of intimate visual material. And for those reasons, we're supportive.
Okay, any questions for Mr. Shelley? Hey, Ms. Jones?
I have one that explained to me the joint and several liability.
Sure. So we're in Civil Practices and Remedies Code here, section 98B.0021. And what we're saying is anyone who aids in the creation of this material, if it is their AI application or software that is used to create this material, and that is done without the consent of the individual who is depicted, then that person is jointly or severally, jointly and severally liable in a civil action for damages.
So that's when I don't get my friend to help because I suck at doing AI-generated stuff.
I suppose so.
My friend helps me.
And it's your platform, your software, correct?
Thank you.
Oh, I'm sorry. Did you hear what I said? I'm sorry. He told me my mic wasn't on. I have a booming voice. Oh, I'm sorry. So if I go get my friend to help me because I can't do it, but it's on my platform, but it's his application, then he's joint and severally liable. So basically, what I end up deep faking, since he helped me, then he's responsible civilly.
That's correct, yes.
Okay, all right.
And again, without consent of the subject
Right.
or victim.
Right.
Okay, any other questions, members? Okay, thank you for being here. Anyone else here to testify for, against, or on House Bill 1121? If not, the chair would recognize Ms. Gamis to close.
Once again, thank you, Chairman, members. I do believe HB 1121 is going to update the Penal Code and the Civil Practice and Remedies Code to address the very real 21st century threat that individuals are finding themselves facing these days in regards to their intimate visual privacy. So I respectfully look forward to working together with you to further this issue. And I close.
Any other questions?
If there are no questions.
Okay, thank you very much. If there's no objection, the chair will leave House Bill 1121 pending for now.
Thank you so much, Chairman. Thank you, members.
Ms. Jones, are you ready to do yours?
Oh, for sure.
Okay, the chair recognizes Ms. Jones to lay out and explain House Bill 463.
Thank you, Mr. Chair and members, for allowing me the opportunity to lay out House Bill 463, which I call the No Drugs Found Equals Expungement Bill. A committee substitute is coming, and I'll get it to you before we vote. Last session, this bill made it out of the House and was placed on the intent calendar in the Senate, but unfortunately, we ran out of time. The purpose of the bill is to ensure automatic expunction of all arrest and conviction records for people charged with controlled substance offenses when lab results show that there's no controlled substance present. Let me be clear, this is actually an actual innocence bill. People who are wrongfully arrested, convicted, or whose charges are dismissed deserve to have their records cleared automatically and without cost. This is about fairness, justice, and basic human dignity. These are actually innocent people, no drugs, no crime. They should not carry a permanent record for something they didn't do. As a criminal defense attorney, I've had clients plead guilty to drug charges they didn't commit just to go home. With court backlogs, trial wasn't a real option. Months or even years later, I've literally received letters from prosecutors saying, oh, by the way, the lab results came back and they were negative. No drugs were there. By then, I couldn't even reach my clients. The authorities didn't clear their records. They were just given notification that there were no drugs. Even dismissed cases are treated like technicalities. People are denied expunctions because the state won't admit that they were innocent. That's not justice. My clients often tell me, I should have fought that first case. That one case, often a misdemeanor, gets them stopped more, questioned more, judged more. One conviction becomes a scarlet letter, and that letter might as well be a C for convict. Let me skip all that stuff. This bill affects poor Texans. Across with all backgrounds and are arrested for drug offenses at higher rates. Black and Latinos are arrested at higher rates for drug cases. It's a barrier to employment and housing. It used to be that employers and landlords only ask, have you been convicted? Now they're asking, have you ever been arrested? And even if the case was dismissed, people are being excluded from jobs and housing just because of an arrest. Even when they show proof of the dismissal, many employers and landlords assume that they got off on a technicality and were really guilty, just like police often do. A dismissal should mean freedom, not a lifetime of doors slammed shut. These aren't cartel cases. Most are less than a gram charges, something you literally cannot see with the naked eye. And that's a state jail felony. People are being charged and convicted of felonies for something that sometimes isn't even there. When a lab proves that their record should be cleared automatically. Our courts are overwhelmed, forcing people to pay for and file expunctions. It's a waste of money that wrongly arrested or convicted people often don't have. It's also a waste of money for the state to house in jail or prison innocent people after lab results prove there were no drugs at all. HB 463 eliminates both burdens and brings needed efficiency and justice to the system. HB 463 would amend Article 55A.053 of the Code of Criminal Procedure to require automatic expunction when lab results show no controlled substances and the case is dismissed or the person is exonerated. It brings in line the law with basic fairness and science. If there's no evidence of a crime, the state should erase the accusation. In 2021, get this, Texas law enforcement made over 90,000 drug-related arrests. Thousands of those cases were later dismissed, yet the arrest records still follow people, especially in communities of color. HB 463 has no direct cost to the state. In fact, it will save money by reducing the need for fee-based expunctions, cutting court backlogs, and eliminating jail costs for people whose labs come back clean. Expunctions today cost thousands of dollars, money most working Texans don't have. This bill removes that financial barrier. Some people are still serving time in TDCJ for drug convictions where no drugs were found. This bill stops the state from spending taxpayer dollars incarcerating innocent people. This bill does not require new spending. It results in real savings for the state and counties while delivering justice. I'm happy to take questions. I believe there's at least one witness, and I reserve the right to close.
Okay, any questions for Ms. Jones? Yes, Mr. Money.
All right. So in the scenario that you discussed where the person has already been convicted, they've pled guilty, would this help that person? Are they going to be, this talks about a case being dismissed, but is it going to?
No, it's going to help that person. So, because
Okay.
there are people that will plead guilty just to get home. They didn't have any drugs, but they just couldn't wait. So if you are convicted and a lab comes back, I literally have received a letter saying, oh, by the way, there were no drugs in the sample, and my client was already convicted. I didn't know where my client was. I couldn't find my client. It's years old, and they are stuck with a conviction for a controlled substance when literally there was not none. So it exonerates those people as well.
It expunges it, even if there's a conviction on the books, because in order to get that conviction at trial, like I said, I don't.
Or in a plea.
I don't practice, or in a plea, I don't practice criminal law, but I've watched people practice criminal law, and the at least in our county, the defendant has to say, I'm pleading guilty because I am guilty and for no other reason. And so they've pled guilty, even though they may not be guilty because they need to get back to work or whatever the case may be. And then the lab result comes back 6 months, 8 months, a year later.
2 years.
2 years, 3 years later, and says, hey, this was a dime bag of oregano, like the Few Good Men. So that this would actually expunge that from the record. What if it's are there cases where they see trace amounts of something in the person's, pipe
So no-
or whatever, and then they go and test it. And I mean, I'm not as familiar with the testing, but are we?
Generally, this is a DPS lab. So, like, say you send something to the Harris County Forensic Center, which is our local forensic center, and it'll say no drugs. Of course, the police, the prosecutor's like, oh, we don't believe that. We're going to send it to DPS. So they'll send it off to DPS, and it'll come back from DPS saying no drugs. And DPS has more extensive testing sometimes if you ask for it, and there's no drugs. So this is a case literally where you're actually innocent of possessing a controlled substance because there is no controlled substance. So this isn't dismissals in the interest of justice. Whatever that means. This isn't dismissals for anything other than we sent the lab off. The lab said that there is no controlled substance.
But this is not just pending charges. This is even post conviction, because that conviction is a plea. But even post conviction, this would still apply.
Absolutely. I mean, you pled for whatever reason. I have had cases where I want to fight a case, and my client, literally like Ms. Jones, when his trial set. Well, it's 8 months away. Ms. Jones, I can't stay locked up for 8 months, so I'm just going to plea. And in order for a plea to be accepted, you've got to say I did it. If the defendant gets up before a judge and says, Judge, I'm doing this, I'm really innocent, but I just can't wait for 8 months, the judge's going to say, I reject that plea.
That's right.
Right? So you really are under duress to get back to your life, and that happens often. Plus, most times on these less than a gram cases, which I say again, you cannot see with the naked eye, nor can you see it with a microscope. You'll have the state say, I'll offer you time served. So if you've been locked up for 8 months, and the state says, hey, if you plead guilty, I'll offer you time served, and you have a trial set 8 months away, or maybe trial's not even set, and it's going to be longer than that, people are going to take that plea all day, every day, and deal with the consequences later, because it's more important for them to get back to their life than to stay locked up.
Okay, thank you.
Okay, any other questions? Yes, Mr. Loudback.
Representative Jones, is the, do you know of any cases or within the DA system and prosecution where this is already available?
I mean, this is already available.
Yeah, the expunction is already available.
No, I don't. And I wish Representative Curry was here, because he actually wanted to speak on this, but I think he had to do something else. Because he's had this happen to his
Is there a
brother.
resource with this you have?
Well, Representative Curry was going to speak, and the usual suspects who would be against it, like Ray Hunt, they're not against it because this is actual innocence. And I know that people don't want to appear to be soft on crime because somebody got arrested for a drug case, but this is literally only actually innocent people. And I would encourage you to speak with Representative Curry. I wish, like I say, he said he was going to try to be here. He can't. We spoke this morning because this actually happened to his brother, which is why he's one of the joint authors of this bill. He understands that it happens. It shouldn't happen, but it does happen. This is an imperfect system. And apart from that, if you got arrested and there were actually no drugs, why should you have to try to come up with money to try to get an expunction when you didn't do anything? And generally speaking, if you have money, you can afford independent testing and maybe have a better chance to do that. But when you're poor, especially in indigent defendant cases, it's just very difficult. You have some judges, if I file an ex parte motion for testing, so I go to the judge and I say, hey, Judge, I'd like to be able to go test what they say is drugs. Some judges won't even give me that testing. And I'm a court-appointed lawyer, so my client already has been determined to be indigent, can't afford a lawyer, and they have no way to have their own independent testing. So it's a travesty. The first time I got a letter, I thought there must be some mistake, but I've continued to get them. But meanwhile, back at the ranch, my clients are locked up.
Can you inquire as to whether or not this process is already free and legal to do already? Make sure that that's not in place already.
I can tell you it is not in place. You have to pay for expunctions. Not only do you have to pay a lawyer to do the expunctions, I do expunctions, I'm not telling you how much I charge, but you probably wouldn't want to pay it. But you also have to pay law enforcement agencies or whoever to clean their records. And
We just got that in an order.
say that again?
We just got that in an order. We got
Right, but you've got to go to a court to get that, and you got to pay for it. It's not automatic.
Yeah.
Now, if you have a not guilty, then it is done. But these are people who pled for whatever reason, and the lab test from DPS came back and said there literally are no drugs. This is clearing the records of people who are actually innocent.
And what's Ray Hunt with HPOU, Houston Police Officers Union?
Yes.
Is he? What is his position on the bill?
Well, he's not against it. In fact, he was here before. We didn't know when I was going. So he's not against it.
Is he neutral?
He said that so before he thought that the expungements were for any dismissal. And I'm like, no, these expungements are only for no controlled substances tests. And he says, I removed my being against. I believe there's a witness here. I'm almost certain.
There is. And Mr. Hunt did sign an affirmation that he was on the bill, which not
Okay, so
for or
initially
against.
he was against it because he thought that it was a blanket. If it's dismissed, it's expunged. And I'm like, no, this is only where the lab says there are no controlled substances. So he's neutral.
Thank you.
Thank you.
So-
And I reserve my right to close.
You got it. So the chair will call David Hart.
Chairman Smithy and members of the committee, thank you for the opportunity to speak today to support House Bill 463. My name is David Hart, and I'm here on behalf of myself, no affiliation. My name is David Hart. I'm a father. I'm a business owner. I'm a firefighter. I'm an air conditioning owner. I'm a sergeant first class in the military.
Sir, let me interrupt. Let me make sure you said your position on the bill.
I am supportive of
Okay,
House
great.
Bill 463.
Thank
Yes, Chairman. Thank you. 20 years ago, I was a young man completely lost after a series of devastating events. At 19 years of age, I lost my father. In March of 2003, I lost my wife. November of 2003, of a drug overdose, namely to a possession of a controlled substance, methamphetamines. I was a widower. I was raising 2 babies on my own, and I didn't handle it well. I did fall into an addiction. I made poor choices and ended up with possession conviction that's followed me ever since. I've owned it every step of the way. I've got clean, I've got help. I've never looked back. I spent the last 2 decades rebuilding, not just for myself, but for my family, my community, and for everyone needing to show up. Community support, funerals of children that I don't even know, businesses giving back, hiring people that need second chances, all because I know what that feels like. The scarlet letter that I've wore on my back for 20 years. Now let me be clear, House Bill 463 does not apply to me because I was convicted. Okay, I want to just state that. House Bill 463 is where the cases were dismissed and where people are actually innocent and cleared by a laboratory. And I understand that. So you'll ask me, David Hart, why are you standing here today then? You are convicted. You did possess these drugs. You did violate this law, right? For me, it's a step in the right direction. It recognizes that not everyone that gets arrested deserves to carry that weight forever. And it gives people the chance to clear their name when the system gets it wrong or when life hands them something that they did not ask for. I am living proof of what's possible when someone is given room to turn it around. My story did not end with a dismissal. My story ended with a burial. And at 19 years old and an addiction, If we can make this easier for people to move forward when they know, when they've done nothing wrong, or when the process has failed them, committee members, that's not soft. That's smart. Everyone deserves a chance to move forward, and this bill opens that door just a little bit wider. I'll say real quick, I've got a guy that I serve with right now who was charged with the possession of a controlled substance. He had Adderall in a 7-day pill container. He had a prescription for it. He was arrested. He was charged with possession of a controlled substance. I served with this guy. He's been a member of the military for 25 years. He is not entitled to an expunction because it is a controlled substance, although he had a prescription and it was dismissed. He was charged and he has to disclose that from here on out. My understanding with 463, when these charges are dismissed or if they're found innocent, this gives them that entitlement to that expunction underneath the statute. I appreciate your time this morning getting to speak to you.
And thank you for being here. Any questions, members? Thank you very much, Mr. Hart, for being here.
Thank you.
Is there anyone else who wishes to testify for, against, or on House Bill 463? If not, Ms. Jones, we'll recognize you to close.
Yes, Mr. Chair. Unfortunately, Rep. Curry is on the House floor, where we'll be going shortly. HB 463 is a bold, necessary step towards justice, fairness, and truth in Texas's criminal legal system. It addresses the real-world consequences of wrongful arrests and convictions, particularly for low-level drug offenses, and gives actually innocent people a clean record and a real chance. Mr. Chair, members, I respectfully request your favorable consideration of HB 463, and a committee substitute will be given to you before we vote. Thank you.
Any questions for Ms. Jones? Mr. Louderback? Oh.
Representative Jones, would you check Code of Criminal Procedure 55A at some point in time here in the future, and get with me, get with the committee before, check it out. Look at that. I believe it waives court costs, 30 days, several things in 55A. Thank you.
So I haven't looked at it, but I can tell you in real-world practice, prosecutors' offices do not like to sign off on expunctions. It's very rare. They want a trial with a not guilty. Judges, too. And what I explain to my clients when I'm representing them is sometimes things affect you that have nothing to do with the merits of your case, i.e. no judge wants to be the judge that lets somebody out on bond, or a judge that signed off on an expunction and somebody goes and does something later. And again, I absolutely don't believe that that's the case for these, but most people in the criminal justice system, from the prosecutors to the police, want to leave convictions alone. They just do. But I will look at it, and if you want for me to come to your office and speak with you about it, I will. But I would just say for this, Ray Hunt and I have gone to battle. I used to be on city council. We were over HPD, and he was over HPOU, the Houston Police Officers Union. So if Ray Hunt is neutral on this, it speaks volumes. Thank you, Mr. Chair.
Anything else, members? Okay, thank you, Mr. Appreciate it. So if there's nothing else on, no objection, the chair will leave House Bill 463 pending. Mr. Ginn, we've only got about less than 10 minutes. I'm sorry, you've been waiting, but can we put you on first when we come back? Okay, so we're running against the clock, so at this time, the chair would move that the committee stand in recess until final adjournment or recess of the House or during bill referral if permission is granted. Is there any objection? Hearing none, the committee stands in recess.